Weekly list old matter item number 1.
None appears dismissed on opposition.
Weekly list old matter item number 2.
Your Lordship, item number 2, 8,161.
Yeah, anyway, it's their appeal. So their revision. None appears dismissed on opposition.
Sorry.
Weekly list old matter item number 3.
Lordship, item number 3. I don't say there is on the face of the record, there is no merit. Your Lordship, however, your Lordship may kindly turn to page 5, the question of law. Whether the facts and in the circum the tribunal is correct in law in arriving at the conclusion that prawn, etc., were purchased the assessee in course of export and therefore these were exempted from levy of tax under the State Act. When the tribunal has not given a finding as to the specific contracts with the foreign buyer in pursuance to whose the purchases were made, your Lordship may kindly turn to the tribunal's order. In tribunal's order, your Lordship, page 29, internal page 6 of the tribunal's order, paragraph 6. Your Lordship, I'll not waste your Lordship's valuable time by placing all these, your Lordship, prima facie on the face of this paragraph 6.
So
all the materials have been produced
confirming an earlier contract, correct?
Your Lordship.
Correct.
So also rejection order is
so
there.
This purchase was in the course of export.
Your Lordship.
All right. You said the short question that is sought to be urged for consideration by this court by the revenue in the present revision petition arising from an order dated 2nd November 1989 of the Orissa Sales Tax Tribunal is whether the tribunal was right in law in concluding that prawn, etc., purchased by the assessee in the course of export was in the course of export and therefore exempt from levy of sales tax under the Orissa Sales Tax Act 1947 question mark paragraph. This court has heard the submissions of Mr. Mishra, learned standing counsel for the state, and also perused the impugned order of the tribunal. Full stop. The court finds that there is a detailed discussion of not only the contract leading to the export made during the year in question, but also the fact that letters of credit were opened for such purchases in the course of export. And therefore, there was adequate material available to the tribunal to come to the conclusion that the prawns, etc., purchased were in the course of export. Since the finding is purely factual and based on the evidence before the tribunal, the court does not consider any substantial question of law arising from the findings of the tribunal. The revision petition is accordingly dismissed.
Weekly list item number 4.
Your Lordship, item number 4, your Lordship, even though there are multiple, your Lordship, even though it is paltry amount, but it is covered by your Lordship judgment, so far as the gonny bags are to be separately charged at its appropriate rate, your Lordship.
All right. Then let's leave the question saying it's covered.
Your Lordship,
so the question sought to be urged by the state in the present revision petition stands covered in its favor by the order dated 19th April 2021 in STREV 80 of 2006 bracket Messrs. Sri Durga Rice Mill was the state of Orissa.
Your Lordship, item number 5.
The revision petition is accordingly disposed of.
Sure.
Item 5.
Paltry amount, that is 16,032.
With the tax amount being insubstantial, court leaves the question of law open and disposes of the petition.
Item number 6.
None appears dismissal or prosecution.
Item number 7.
No instruction, Lordship, no instruction.
Counsel, the petitioner states that there's no instruction. Petition.
Item number 7.
7 only.
Sorry. Item number 8.
None appears dismissal or prosecution.
Weekly list item number 9.
I may be permitted to withdraw, my lord. It's infructuous.
Right. Counsel, the petitioner states that this is infructuous. It is disposed of as such.
I lose.
Weekly list item number 10.
Item 10, your Lordship, Wait, please, my lords.
Item 10, Your Lordship, in behalf of the state, we had already filed a counter, but since the petitioner had filed a consolidated writ petition, the parawise we have received. If Your Lordship allows us, we can file it within a week. What's the matter about the challenging?
My lord, the petitioner was granted a lease in 1977. Now, in terms of Section 8A, amended Section 8A of the MMDR Act, the petitioner is eligible for a grant of period of 50 years from the original grant. So the lease has to be extended till 2027.
The Lordship, there is a representation which is pending of 2015.
My lords, the representation is pending since 2015.
So
all the matters can be
that-
covered, heard by
Lordship,
this honorable court.
In the present case, the petitioner,
If they're prepared to consider your representation, you should be happy.
My lords, they have not considered since 2015.
He's prepared to do it now.
Your Lordship, for the lease, supplementary lease deed to be executed, the petitioner needs to have certain statutory clearances.
That is for the
And
mining
here another issue which has cropped up is the 27 hectares of the land comes in the buffer zone of the elephant wildlife sanctuary. That is one of the issues which is involved. So the opposite party may be directed to consider the weapon in accordance with law.
My lord, what my learned friend says, for mining operations, the clearances are required. For mining operations to commence, I have to first get a lease deed. I assert my rights under Section 8A for extension of the lease deed. Then only I can apply for the clearances after getting the specified area. Specific area.
Areas being given to you for mining, correct?
Now it has to be extended because as of now, there is no mining lease.
If there is a bar to mining on certain areas because of it's part of an elephant corridor, then why should they give it to you on lease at all? What will you do with that land?
Only
You
a
cannot
part.
use it for any other purpose.
It is their allegation, my lord. It is their averment that it is only a part of it comes under the elephant corridor. The rest they have to grant it to me.
No. Are you prepared to say I'm giving up that area then, which is covered by the elephant corridor? You make that statement, then we'll ask them to consider for the rest, subject to statutory clearances.
It has to be determined, my lord. They may ask.
No, they've already earmarking. You're able to earmark which area is elephant corridor.
Your Lordship, the area is 27 hectares. That the demarcation, Your Lordship, that could be
Nothing has been
the area-
specified, my lords. They have never
given
given it to me also.
in the counter which had filed the previous counter, because the petitioner has filed a writ petition earlier with a portion of the prayer which is presently alive. In that, Your Lordship, we have stated the buffer area comes around to 27.22 hectares.
No. Have you earmarked it?
Your
Where is that counter? Which page is that?
Lordship, page 37, annexure C/1. 39.
No, this is letter to the forest department.
Lordship.
No, but what you're including is the
my lords may
petitioner's own
see-
letter.
My lords may see what is there in page 37, what my learned friend is pointing out. The state government has rejected renewal application since the applied area comes within buffer zone of Elephant Reserve project of Mayurbhanj district, as reported by Director of Mines. But Honorable High Court of Orissa, via order dated 16/11/2006, have directed the state government to afford an opportunity to the petitioner to supply any documents and thereafter give an opportunity of hearing to the petitioner before passing any final decision. That has been quashed, my lords.
Not quashed. Not quashed.
No,
That was quashed and it was asked to be, they were asked to hear me on this.
Since Lordship, the rejection of the renewal application was without an opportunity, this honorable court granted him an opportunity to submit the
that, my
necessary
renewal-
documents. And thereafter, this letter has followed up after that order, where the forest department has been asked as to whether an NOC is required, since the applied area comes within the buffer zone of Elephant Reserve project. There is an observation here at the second para, Your Lordship. The petitioner was asked to produce NOC from the concerned authority since the applied area comes within the buffer zone of Elephant Reserve project.
So have you applied for this?
My lords,
Have you applied for this NOC?
The NOC I have to take instructions must have been applied, or in terms of the new rules, it may not be a requirement because the new rules OMMC 2016 in Rule 12 states what are the requirements.
No, but if it is part of the elephant buffer zone of the elephant reserve project, why would you be exempted from obtaining an NOC?
My lords, I am placing Rule 12 of the OMMC Odisha Minor Minerals Concession Rules 2016. Mining operations, Rule 12.
Yes. Yes, please.
Mining operations. The holder of a prospecting license cum mining lease shall commence mining operation in the area if he has obtained A, mining plan duly approved by authorized officer, B, clearance under Forest Conservation Act, C, environmental clearance, D, consent to establish and consent to operate under Water and Air Act, E, permission for surface operations. These are the 5 clearances required, my lords.
This is before commencing the mining operation.
My lords.
I think here what they're asking for is something different.
Also, no forest land is covered under the area.
No, buffer zone is something else. See, this is part of an elephant corridor. The elephant reserve project comes and probably in the Wildlife Act.
In case the buffer zone has to be excluded, that can be intimated in the supplementary lease deed. That part can be removed, that area.
You make a statement, then we can ask them to consider. Once you make a statement that you are not, that can be removed.
If the petitioner consents to surrender that portion of the lease area which comes under the buffer zone, then the application could be processed without considering.
You file an affidavit then?
My lords,
Counsel for the petitioner states, you see, counsel for the state has pointed out that by a letter dated 26 June 2007, the Department of Steel and Mines informed the Forest Department that the petitioner has been asked to produce NOC from the concerned authority since a portion of the applied area for renewal of mining lease comes within the buffer zone of the Elephant Reserve project. Paragraph, counsel for the state says, informs the court that this is to an extent of 21 point.
Lordship,
What is the extent of this area which is covered by the
27.22 hectares.
This works out to 27.22 hectares. Full stop. He states that if the petitioner is prepared to make a statement that his application for renewal of mining lease can be considered by excluding the above area, then the application will be considered in a time-bound manner, subject to compliance with all other statutory requirements by the petitioner. Paragraph, counsel the petitioner states that he will file an affidavit in this regard before the next date. 22nd August,
My lords.
pass.
Obliged, my lords.
List item number 11.
Item number 11, your lordship may permit me to file an appeal.
All right. Counsel the petitioner seeks leave to withdraw the present petition with liberty to file an appeal before the appellate authority in accordance with law.
The originals may be returned.
All right. If such appeal is filed not later than 22nd August 2022, accompanied by an application for condonation of delay, explaining the pendency of the present petition as the reason for the delay, it will be considered in accordance with law by the appellate authority. The court clarifies it has not expressed any view in merits.
The original,
Further, if such appeal is accompanied, if such appeal come up filed within the time stipulated, is accompanied by an application for interim relief, then the interim order passed by this court on.
the
No, there's no interim order.
No interim order.
No interim order is there.
Or just take that off.
The originals
Then
may
the
be
originals be returned to the petitioner, subject to being substituted attested photocopies.
the connected matter has already been disposed of on 29th of March 2022. Milods. There's a connected matter of WPC 18456
Yeah, 18456 of 2014. This has already been disposed of and
on
need not be
29th of March.
shown. Yeah. 29th March 2022 need not be shown in the list. Right.
Greatly obliged.
Right.
Weekly list item number 12.
May I please, Your Honor? The Tahsildar resumed the land illegally without giving notice. As I am the purchaser from the original lessee. Already this Honorable Court has remanded the matter on many cases to the Tahsildar to give me a
date of the purchase, sir?
Purchased in
91.
order is 98.
I see. On the short ground that the petitioner had purchased the land in question on 27 September 1991 under a registered sale deed prior to the impugned cancellation order, presumption order dated 18 June 1998, passed by the Tahsildar Bhubaneswar in WL case number 349 of 1985. And no notice was issued to the petitioner prior to such order, comma. The impugned order is hereby set aside. WL case number 349 of 1989 will now be 85 will now be listed before the Tahsildar Bhubaneswar on 7 September 2022,
Tahsildar or additional Tahsildar?
on which date the petitioner will appear together with a downloaded copy of the present order. The Tahsildar will then proceed in accordance with law and after hearing the petitioner pass appropriate orders disposing of the aforementioned WL case number 349 of 1985 within a period of 4 months thereafter. The court clarifies it has not expressed any view on merits. The petition is disposed of.
Weekly list item number 13.
Obliged.
13.
My lord, one.
Well, Lord, I'm
Also, my
on behalf of opposite party.
Item
My lord,
13.
one. Pass over, please.
Or it passes.
Weekly list item 14.
May I please, Your Lordship. This is a matter regarding the release of ex gratia compensation was expired in the stampede in the car festival in the year 2011, Milo. Kind of a glance to even the postmortem report and dead body carrying certificate, where from it is clear that the person who was witness to the car festival on the day because of this traffic jam has expired. And the temple administration.
Anyway, your representation is still there.
Repension is there, my lord.
All right.
And
the petitioner's
similar
representation dated 27th December 2011 will be examined by the Jagannath Temple Management Committee.
Please. The SJTM, Sri Jagannath Temple.
The Sri Jagannath Temple Management Committee, party number 3.
Well, compensation sought for from the state government. Prayer, Your Lordship, see, ex gratia compensation from the state government.
Will be examined with the collector Puri. And after hearing the petitioner and any other parties as are considered necessary, including opposite party number 3, the reasoned order shall be passed thereon not later than 10th October 2022 and be communicated to the petitioner not later than 17th October 2022. The court clarifies it has not expressed any view on merits. All right.
Item 15.
Right.
In Milo, lease was granted in the year 74, Milo. The first purchase
prior to the order. Sold it prior to the order.
Oh, I see.
But only thing is that the matter should be remanded confining to the petitioner's purchased land, because vast land is cancelled and only the portion he has purchased.
Here, what happened, Milord, that in view of section 7A3, Milord.
You're passing the same order, sir. You're passing the same order. The petitioner has purchased the portion of the land in question.
He's a third purchaser. But all the sale dates are prior to the
under a registered seal deed, which was prior to the date of cancellation of the lease by the impugned order dated 30th June 1998. of the Additional District Magistrate, bracket ADM, Bhubaneswar, in revision case number 637 of 1998. Admittedly, no notice was issued to the petitioner prior to the impugned order being passed. Paragraph: on the above short ground, the impugned order is set aside to the extent of the land purchased by the present petitioner.
Yes.
And to that extent, the revision case number 637 of 1998 is
Will be
restored to the
the
file of the ADM Bhubaneswar. Full stop, it will be listed there for hearing on 12 September 2022, on which date the petitioner shall remain present with a downloaded copy of this order. The court clarifies it has not expressed any view on merits. Till such, the ADM is requested to dispose of the said revision case within a period of 6 months thereafter. All right, the petition is disposed.
Item 16.
Item 16, Your Lordship, brief has been transferred, Your Lordship.
All right, counsel the petitioner states the brief has been transferred, none appears for the petitioner.
Our name may be deleted, Your Lordship. Mr.
It's
Pal.
all right, it's all right. Dismissed.
Weekly list item 17.
Let's, on transfer of the brief, I am appearing for the petitioner and filing the wakalatnama along with a 2-page date chart only.
Tell us.
Your Lordship, the name of Mr. Rautra and Associates be deleted, Your Lordship. The file has been transferred.
All right, sir.
May I please?
Yes, please.
As this is a case where the petitioner has claimed regularization with effect from the date of his juniors were regularized in the post of helper. Initially, the petitioner was engaged as an NMR in Khurda Electrical Division of the Orissa State Electricity Board in 21/3/1987. Then in the year 93, the OSCB decided that the NMR workers who have completed 400
Why is it
days.
before the division bench? This is not a challenge to any SAT order.
It is single bench matter.
It's a single
This
bench
before
matter.
the prostrate single judge. On 24th August.
24 August.
Weekly item 18.
Obliged.
May I please, Lordship? One of the petitioner is challenging the issuance of summon by the learned family court Berhampur, my lords, in CP case number 97 of 2011, my lords.
My goodness, for 10 years you've stayed the family court proceedings.
My lords.
There's a stay for 10 years, sir, of the family court proceedings. The whole family court matters are supposed to be disposed of in a time-bound manner. You've got it stayed for 10 years now. What is the ground? Why are you resisting even summons?
My lords, several applications were pending for restitution of conjugal rights, my lords. I had filed an application, my lords. And regarding the custody of the child, I had also filed an application.
So how old is the child now?
At that time, he was 7 years old, my lords.
How old is he now, sir?
17.
No. This is 2011 summons were issued.
Yes, ma'am. More than 18 years. Ma'am.
I thought my arithmetic is very bad. Yours seems to be even worse, sir.
I'm sorry.
Huh? How old is he now?
$17 years, my lord. 2012, he was 7 years, my lords.
2012, he was 7 years. What is the date of birth?
Date of birth is not been mentioned, my lords.
What is the grievance? We are still not able to understand. What is your grievance? Why are you resisting the summons?
The matter was kept for conciliation, my lords.
So you can go to the family court and ask for conciliation. Why should we stay the summons?
Liberty may be given.
There's no ground made out for staying the summons issued by the family court to the present petitioner. Paragraph. Counsel to petitioner states the petitioner is willing to explore the possibility of conciliation. To stop this request can well be made before the family court concerned. The interim order is vacated, the petition is dismissed.
Weekly list item number 19.
19, I am appearing for the opposite parties, Lordship.
The copy of the order be sent to the concerned court. None appeals to the petition. Dismissal not possible.
Weekly item 20.
20, my lord, the grievance of the petitioner already redressed by the
All
opposite
right.
party.
Constitutional petitioner states the petition has been rendered infructuous. So the post of knowledge.
Weekly list item 21.
My lord, in this case, the brief has been transferred to the.
All right. Constitutional petition says brief has been transferred. None appears to the petition.
And
Dismissal not possible.
transferred to me, my lord. The brief was transferred to me today. I was
Tell us what the matter is about.
urgent to any other day.
No. Tell us what the matter is about.
Because I have not properly gone through the relating.
We'll help you, sir. We are here to help you.
Promotion of the petitioner, where his juniors were promoted, his case was not considered. Further, he has made an representation different times.
He is now attained superannuation.
My lord,
he is superannuated, sir. How old is your client?
Yes,
Has he
yes.
superannuated?
At the time of filing, he was at the age of 51. In the meantime, he has been superannuated. Yes. Ma'am.
So nothing survives.
Yes. Ma'am.
Since the petitioner has been superannuated in the meanwhile, the petitioner states that petition has been rendered infructuous. It is disposed of as such.
Weekly list item 22.
May it be well. Impugned annexed is annexed 8 at start space 70 man. Wherein the last portion
50,000 to the disputed workman is compensation.
Yes, madam. To be announced only, nothing else. Because
sorry,
50,000 has been given. 50,000 given. I pray. My prayer is to enhance that company.
How long did you work?
6 to 7 years, madam.
6 years, sir. What were you working as?
As a badli worker.
Casual worker. Sir, this is an award of 2012.
Yes, ma'am.
50,000 is not unreasonable at that point in time, sir.
2001, 2011, 18
this was not unreasonable at that point in time, sir. The short ground on which the workman seeks to assail.
One point, madam. Because the management has challenged this award also. And some time ago, in the month of March, that has been award has been upheld, madam.
That's it. Then all one more ground, sir.
I'm appearing for the opposite part number 2, my lord. We had filed WPC number 16603 of 11. And by order dated 22nd March, the award has been.
That's what he's saying, sir. That's
Yes,
what
sir.
he's saying. The challenge to the impugned award by the management has already been rejected by this court. Paragraph: the workman has filed the present petition challenging the award, seeking enhancement of the compensation. Paragraph: admittedly, the workman is working as a casual worker for a period of about 6 years. The compensation award awarded to him is 50,000 by the impugned award. Considering that the award was made in 2011, pertaining to the termination of the petitioner's services, which were rendered for a period of 6 years, between 1990 and 96. Between 1986 and 1992, the court does not consider the amount to be unreasonably low, calling for any interference. The petition is accordingly dismissed.
Weekly list item 20.
My lord, may I pray one thing, my lord? My lord, may I pray one thing? Can there be a direction? Can there be to the management? At least he is ailing, my lord. 50,000 amount may be given to him, my lord. Because by the order of the state.
Who prevented you, sir? There's no stay of anything.
No, at present there is no stay, my lord. Stay was operating against me, my lord.
When?
In that writ application filed by the management, wherein I was not given a copy, my lord. I was not noticed.
Anyway, sir, you did not file a 33C or anything like that. You didn't ask for enforcement. You didn't apply here to vacate the stay.
I have filed in this application, my lord. This
Or the amount, if not already disbursed, shall be disbursed with the management to the workman now, not later than 4 weeks from today. Or it.
Weekly list item 23.
None appears dismissal, not prosecution.
Item 24.
Lordship, in 23, I'm appearing for the respondent's opinion. OSFC, Your Lordship.
Call out.
Item 24.
May I please, Your Lordship.
Maybe permitted to file fresh wakalatnama, Your Lordship. My name may...
Have you heard the order, sir?
Yes, Your Lordship.
What is the order?
It's an order of dismissal, Your Lordship.
All right.
Name may be reflected, Your Lordships. It's a transferred matter, Your Lordships.
All right, sir.
Item 24.
May I please, Your Lordship. But here, a demand notice under challenge, my lord, under Annexure 5, and it has been not been given an opportunity. Lordships are directing that Commission Excise will examine the matter and will give an opportunity.
All right. Same order in all these matters.
There are two matters at same. 5733, 11,495 is both, in both the cases, demand notice are there.
Okay. First two matters, the same.
Other two cases, infraction.
Other two, you say petitioner states the petition has been rendered infructuous, disposed of as such.
Weekly list item 25.
None appears dismissal, not prosecution.
I am appearing for response number 3.
Weekly list item 26.
Order is vacated.
26, my lord, the brief has been transferred. The
All right. Counsel for the states, the brief has been transferred. None appears to the petitioner. Dismissed. Not prosecuted.
Weekly list item 20.
I am appearing, my lord. Opposite party. No.
Item 27.
May I please, Your Lordship. 26, my lord. 26, my lord, adjourn.
Tell him what happened.
26 non-affair dismissed.
My
Item number
appearance.
27.
Union of India appearance.
Item number 27.
May I please, Your Lordship. But here, the decision of the corporation issuing no due certificate under Annexure 4 in favor of the opposite party, private opposite party, despite the fact that in a 31 proceeding, they were directed to have a fresh auction after it was held by the competent authority under the statute that the previous proceeding was bad in law, which was also confirmed by this noble court, is under challenge. And this Annexure 4, the no due...
Who are you, sir? I'm not able to understand. What is your locus? What is your relationship?
I took loan, my lord, from the OSFC for the purpose of prawn culture. After coming into force of regulations, new regulations by the government, my lord, they were removed and I was not allowed to operate. I sustained loss. Default is admitted. There is no dispute. Now what happens? They have the option of taking recourse to 29 or 31 by filing an application before the land district judge.
Now, who's opposite party number 3?
Opposite party number 3, I'll just clarify, my lord. May I just, with your lordship's clarification, permission, place few sequence of facts only. Thereafter, I'll, my lord, place you for your lordship the details. My lord, the OSFC files an application under section 31 of the Act to enforce, my lord, my liability and recovery. They can also take recourse to 29. Now, during pendency of the 31 proceeding before the Lani district judge, they took recourse to 29. Now, my lord, the Lani district judge held that the 31 proceeding is barred by limitation, and they having not taken leave to take recourse to 29 during the pendency of the 31 proceeding, by referring to the decision of the Honorable Appeals Court reported in AR 894 Supreme Court, held that the 29 action is illegal and they can take recourse to fresh 29 action in accordance with law. This was the decision of the Lund district judge, which I have annexed, my lord, as Annexure 3, that is on 9/4/2008. Post facto the disposal of the case, since there was no fresh action under 29, in fact, we also filed a petition before the Lund district judge in the 31 disposed of 31 proceeding, saying that a time limit should be fixed. They filed objection saying that since they have challenged...
You're not explained at all. Somebody is a guarantor.
No, this OP3 has been issued with a no due certificate. The settlement has been made.
What is your relationship with OP number 3? You've not told us.
No, my relationship, I have no relationship with OP number 3. The 29 proceeding which has been declared as illegal by the London District Judge, on the basis of that 29 proceeding, a no due certificate has been issued in his favor by settling the.
Who is he, sir? You're still not telling us who's OP number 3.
OP number 3 has purportedly purchased the property.
Still told that. Only now, after 4 times asking you.
I'm extremely sorry, madam. I'm extremely sorry that I have not been clear on that point, madam. Extremely sorry, madam. I apologize. Madam, the OP number 3 has purportedly purchased the property on the basis of the 29 action, which has been declared illegal by the London District Judge while adjudicating the 31 proceeding at the behest of the corporation.
All right.
My lord. Now, what has happened? My challenge to this this certificate before this noble court was.
What is your problem with the auction purchaser getting a no due certificate? I'm not able to understand.
My problem is this. What has happened, your lordship will see. After I challenged the matter before this noble court was pleased to stay operation of that no due certificate because that was on the basis of a 29 action which was declared as illegal by the London District Judge, and that was also confirmed by the noble court in a FAO.
What is a no due certificate in favor of opposite party number 3 who's an auction purchaser? I'm not able to understand. Why should he get a no due certificate? You're not telling us the full facts. This is the whole problem. What is your issue with a no due certificate being issued in favor of an auction purchaser?
That is because the very auction purchase, which has been on the basis of which the settlement has been effected in favor of opposite party number 3, has been declared illegal by virtue of the judgment under Annexure 3 at page 34, your lordship. And the London District Judge has been pleased to direct that there should be a fresh 29 auction in accordance with law. And this order was challenged for this noble court in a FAO, and this noble court also confirmed it, saying that there is no illegality in the order of the auction purchaser.
Who's for the auction purchaser? Has the auction purchaser been served?
Yes, he is represented through a counsel, your lordship.
Who's that?
I think my lordship, Mr. Milan Kanungo is appearing for him.
Yes, Mr. Kanungo, you're there. He's there on virtual mode.
My lords,
Lordship pleases. Appearing on behalf of OP number 1 and 2 OSFC, Your Lordship, we are filing counter. A small clarification, Your Lordship. The no due certificate happens to be the end case of an auction purchase. That is the format that is followed. A no due certificate is given to an auction purchaser when all the payment has been made. Here, our contention according to the counter that we will be filing, Your Lordships, in the course of the day is that the no due certificate was issued much before the final order of
Lordship's permission. He is yet to give a copy to me, and he is relying upon that and placing it before your lordship.
It's all right. It's okay. We're not sure who's appearing for the auction purchaser.
My lordship, Mr. Kanungo is appearing because on
pass it over. We'll pass it over. Let us see what.
May I just pray before your lordship one thing? I'll give a chat explaining because I have not been that clear to your lordship. Will your lordship take over next week, man?
No. If the auction purchaser is not going to be interested, there's no need for all this.
No, what they have done, there is a contempt in place for your lordship. What they have done, my lord, let me just clarify. Your lordship, this noble court was pleased to stay the operation of that no due certificate. Now, what has happened? Post facto, the interim order passed by this noble court, the opposite party 1 and 2, that is OSFC, have executed a sale deed in favor of opposite party.
You never asked for a stay of that. This is precisely what I was telling my Justice Patnaik. You never asked for a stay of sale certificate.
No, my lord, this is what they had issued. Now they have executed a sale deed. I'm not on that. If your lordship
decides... You're not on that. Meaning you're okay with the sale deed?
No, I'll just clarify one thing. This sale deed, so far as the sale deed is concerned, that will automatically get effaced if your lordship will hold that this action
of the... No, it will not, sir. That's a separate thing. He has paid money. He has paid money in an auction. He's got the property.
But that has been declared illegal. That has been declared illegal and confirmed by the noble court in a FAO.
then you should go in the FAO, sir, not in this writ petition.
No, FAO has been disposed of holding that the direction of the land district judge. May I just place the direction, my lord? Your lordship will see. The direction is, your lordship will only kindly come to the operating portion at page.
How will a contempt lie in this writ petition?
No, I am not on the, well,
sir, this writ petition, if you ask me, is completely misconceived. You should have taken that order in the FAO to the logical conclusion, right? There's no question of filing another writ petition for some no due certificate. And in that, to somehow get an order cancelling the sale deed.
No, I'm not so on the question of sale deed, because once your lordship will hold,
you file whatever proceedings you want against the sale deed on the strength of an order in the FAO. All right. This writ petition is going to serve no purpose.
Ma'am, may I just clarify one thing? Your lordship may kindly turn to page 45 of the brief. They had approached in terms of section 31 of the State Financial Corporation Act before the land district judge. What the land district judge says, my lord. May I just place it, my lord? In view of my discussion above on the above points, I am of the findings that the proceeding under section 31 of the Act is not maintainable and is barred by limitation. The action of the petitioner corporation in putting the properties of the opposite parties in Schedule B and lot number 1 to 4 of Schedule C to sell by virtue of power under section 29 of the Act during the pendency of the proceeding under section 31 of the Act.
Why we're saying whatever is the outcome of this order confirmed by this court in FAO, you work that out, not in a writ petition here. What is this writ petition to do with all of this? There's no prayer in relation to that in this writ petition also.
One thing. My lord, I filed a petition for the land district judge in the disposed of miscase, the 31 application.
Sir, we are not here to give free legal advice. All right.
No, I'm not on the question of advice. I'm saying
so whatever you have done, you have done. Whatever you want to do, you do. As far as this writ petition is concerned, we can find it to be completely misconceived. This is an order asking for direction for staying some no due certificate, which we don't understand what is your problem at all.
Now that is because
you are the main borrower. Why should you be bothered if they're saying there is no dues against this loan? In fact, you should be happy.
No due certificate was a consequence of the auction which has been declared as illegal by the district judge.
They are only asking that what are they saying the certificate? There is this money received as far as this loan is concerned. According to us, no dues are outstanding against this loan. What is your problem on that? You are the original borrower.
Now, your lordship will see my prayer, my lord. My lord, your lordship may kindly see my prayer, my lord, in the writ petition. Not only the no due certificate which I have questioned, I have said that in terms of the, my lord, they should proceed under 29 of the Act in accordance with law.
Mandamus to them, sir. If they choose to proceed, they will proceed. If they don't want to proceed, they don't want to proceed.
But what they have done.
Why should a court direct them to proceed under 29?
Why I have challenged that no due certificate, let me just humbly clarify. An action which was declared as illegal by their own petition in terms of section 31 is being carried out without ballot carrying out the direction that has been issued ballot. Your lordship will see.
So if you go through this no due certificate at page 47, where is there a reference to the auction sale?
Your lordship may kindly see. Yes, I'm much obliged. Your lordship has been pleased to ask me that question, page 47. Your lordship may kindly see that serial number 5, DSC sale letter number so and so. This is 27/3/2022, which has been declared illegal in 2008.
Yes.
This has been declared illegal in 2008 by the land district judge under Annex 3. So therefore, my challenge.
No. This is not conferring title on him.
Yes, but they have.
This is not a declaration of title.
No, this is confirming the auction sale that was done in favor of.
It doesn't say that, sir. It doesn't say.
My lord,
in fact, there is a sale certificate separately issued.
Sale certificate is, your lordship has seen the reference.
You have not asked for any relief against that sale certificate.
No,
even today you are not asking for a relief against the sale certificate.
That sale certificate has been declared illegal. That auction process.
Then why are you worried? What is the problem? What is the problem? I don't understand.
My humble submission is this Annex 4 could not have been issued when the sale certificate has been declared illegal.
How does this hurt you? And when the sale certificate itself is gone, how does this hurt you?
It hurts me. It hurts me because by virtue of Annex 3, The property that
Okay,
was
assuming this writ petition is dismissed, this letter will somehow grant him a perfect title.
no,
No, just answer this question. Suppose we dismiss this writ petition.
Yes.
By virtue of this letter dated 1/1/2012, he will perfect his title.
That is what has happened. And the registering authorities have executed sale deed.
So when was the sale deed executed?
Sale deed has been executed subsequent to the, my lord, order passed by reasonable court. That is why a contempt petition has been filed.
Not contempt, sir. Then you should go in a suit for declaration of the sale deed.
21/4/2018.
So you ask for a declaration of the sale deed to be null and void because you never asked for a stay here.
No,
you made a mistake, sir. You made a mistake in not getting an interim order saying don't execute a sales certificate in his favor. You went and asked for something which is completely inconsequential, which is why you landed up in this mess. You can always file a suit on the strength of the order in the FAO to declare the sale deed to be null and void. There was no interim stay by this court preventing them from executing a sale deed.
No, only the sale deed is being executed on an action which has been declared null and void.
Sir, there is no order by this court on that in that behalf. It's only an order in the FAO, not in this writ petition.
Not in the FAO even. It is under Annex 3 by the learned decision in
This is going to end up nowhere, sir, because you have never, even today, you have not assailed that sale certificate. You only filed some contempt petition.
In contempt,
and the contempt is misconceived because there was no order preventing them from executing a sale certificate.
If your lordship holds that the contempt there, it is contemptuous, certainly your lordship can restore a status quo ante.
No. This is not 142, Article 142, please. There are limits to you. First of all, you have not asked for any prayer on the sale certificate.
But your lordship will see the action of the OSFC, which has been declared as illegal, is being carried out.
Yes.
That is the entire difficulty.
So that is a separate proceeding.
And
the FAO is already over. You're somehow trying to bring all that into this
lordship's kind permission. I may be pardoned, though it is little maybe repetitive. With your lordship's kind permission, may I just produce this document for your lordship's kind perusal?
Yes.
Only this document, 2 documents, my lord. I may be pardoned that your lordship may kindly peruse. I'm also giving a copy to my friends.
What was the total loan amount, sir?
That was, your lordship.
And that loan amount together with interest, if it is not paid. So if the sale has to be declared illegal, that loan is still outstanding then?
Yes.
So what is the add interest? What is the amount?
Well,
you pay off everybody then. You pay the auction purchaser, you pay OSFC.
They sell a property.
This is Article 226, correct?
Mile.
So will you be prepared to make a statement that you are prepared to deposit the entire amount together with up-to-date interest? Will you pay off the auction purchaser? You pay off OSFC.
That is subject to the scheme they have?
No scheme and all. No scheme. You have gone and stayed everything.
Suppose, hypothetically, they have a scheme in place where they exempt some interest. Sir, I'll be benefiting that, man.
You've got a stay against this letter. Since when?
Your lordship.
Since 2012.
Yes.
You start adding interest now to the original loan amount. That entire amount you should be prepared to
let me give a statement that I am bound to pay the loan amount. There is no dispute about that. Because they sell a property worth of 2.5 60 lakhs.
What are you worth today? What are you worth today? What is your capacity to pay now? You tell us that. Simply just stalling everything is not going to serve your purpose.
He is a businessman. And even this property will also...
What is the amount, sir? You get instructions. The loan amount together with up-to-date interest, how much does it work out to? What is the original loan amount?
Original loan amount for the lordship is 19.9 lakhs, the first term loan, and additional term loan of 129 lakhs.
1 crore 29 lakhs.
1 crore 29
No. What was the outstanding, sir? Not the loan amount. What was the outstanding when you put the property to sale? In that auction notice, you would have mentioned the outstanding amount.
Sir, your lordship, according to the counter, it is 4 crore 33 lakhs.
The outstanding amount?
Outstanding amount, your lordship.
So add interest. Sir, will you be prepared to pay that loan plus interest up to date?
Page 18, they have said that outstanding amount is 2 crore 97 lakh as on that date, the filing of the petition.
So you add interest up to date, you pay the entire amount here, deposit it here now. We'll listen to all your great questions of law. We will deal with everything. You pay that amount.
Your Lordship,
We're not wasting our time like this. Either he gets the money or both the auction purchasers get his money and OSFC should get its money.
Let me humbly clarify one thing, that the OSFC has to get its money, which they have given to me.
Auction purchaser, sir, what is his problem? Why should he suffer? He has parted with 59 lakhs, 60 lakhs. Why should he suffer?
In respect of property worth of 2.5 crores.
So you pay him his 60 lakhs plus interest from 2000. When did he pay this? 2012.
Lordship, this
when was the date of the auction?
I pray. Your Lordship,
2012.
Just one
You
minute.
add 10%. You will not even say 18%. You add 10% to 60 lakhs from 2012. You be prepared to pay him straight up.
My lord, your Lordship may fix a date. I'll just take instruction on that point only.
No.
Because just on the spot, my lord, I cannot unless I take an instruction from the client.
We'll pass it up. You have to also pay OSFC, sir. You also have to pay OSFC. Your amount is how much? Reduce 4 crores.
4 crore 33 lakhs.
2-3 days
plus
time.
interest. Plus interest will work out to how much?
Your Lordship may fix it this week, my lord. I'm not saying beyond
we
this
pass it over. Sir, we know these kind of matters. It delays the court. It gets us interim order like this for 10 years with nobody getting anything. Only the auction purchasers left high and dry.
Auction purchaser, this is nexus. Your Lordship will say apparently.
Everything is nexus, sir. Everything is connivance. Everything is, as far as you're concerned, you don't have to part with even 1 rupee.
No, he has to pay.
By making all these allegations, you can put a spanner in the works for 10 years. Nothing will happen. Nobody can sell anything. And you will sit pretty not paying a single penny, sir.
No, he has to pay, my lord.
What has to pay in these 10 years? What have you paid? Nothing.
No, he has paid because all these processes have happened.
Lordship, in the last 10 years, how much money have you repaid to the OSFC? Don't tell us this. You paid nothing, sir. You have paid nothing to the OSFC. In fact, this bench, for staying this letter, should have asked you to pay them straight away 60 lakhs.
My lord, that I would have paid, my lord.
Would have. See, this is all very generous in hindsight.
No, he is bound to.
You got not generous. You quietly walked away with that stay. You never offered to the court, sir, I am prepared to pay 60 lakhs.
He's bound to. It's not generous.
Sir, today you're saying bound to and all that. In 2012, when you came before this court, you would have said, I am in the streets, my house is going away, please stay. This is what you would have said.
Your Lordship may kindly pass over, I'll take instruction.
We'll pass over.
Quickly list item 28.
Yes, item 28. Some conductors of the OSRTC have filed the present writ application. May I please?
Yes, sir.
Some conductors have filed the present writ application challenge of the OSRTC challenging certain deductions. But prior to it, they had filed 2 writ applications, both conductors and drivers, 6218 of 2012 and 6219 of 2012, that they have been being paid at the rate of contractual conductors and drivers since long. There they have filed a counter. Here they have not filed a counter. May I pray, these 4 matters may be taken up together tomorrow, the old matters. Here they are deducting, I have challenged. There they have not filed any counter, but here they have filed a counter, they are paying at the contractual rate. We are working for last 20 years or more as contractual drivers and contractors.
So many of you would have stopped working now, sir. 2012, petition number 1 was 55 years old.
Some of them are still working.
Only some of them, sir, not all of them.
But your Lordship may take it tomorrow or day after so that all the grievances will be redressed. We are getting only 8,000 and some odd.
What is the 1 minute? What is the prayer?
No, here we have prayed. They are directing opposite to pay them the dues as per contract and not to deduct fuel or lubricant damage of tires. Damage of tires and lubricants they are charging from us. We are not responsible. We are conductors. That, but no counter has been filed, though notice has been issued long since. And in the
how is a writ petition maintainable for these kind of things, sir? I don't understand. How is a writ petition maintainable at all?
Millers, it is a state-owned corporation, Millers.
So what?
State-owned corporation, Millers.
That's all right, sir. This is actually for recovery of money, correct?
Yes, but recovery of money. Which is
what is the dues? You've not even quantified your dues in your whole writ petition.
They have not made any dues. They are asking us to, charging us that.
No, you've made some representation, Annexure 2 series. Let them consider this, sir. Let them consider this representation. That's all we can say. At this point in time, 10 years later, with no counter, no details. In fact, you have not even quantified per person how much is the dues. You have not even quantified that.
We are challenging the method of.
You're not challenging anything. Please see your prayer. You're not challenging anything. You're simply saying ask them to pay.
No, we are not here. We are paying millers, not to deduct millers then. Because
to pay dues as per contract.
Yes, brother.
What is the dues? You have not quantified the dues. You have not even told us how much they're deducting. You have not told us how much you have to be paid. Nothing.
In earlier writ application, I have prayed for regularization. So,
no. We are now on this writ petition, sir. This is only for recovery of some money. You have your representation. They let them consider it. You say this is a writ petition filed way back on 28 July 2012. The following prayer, reproduce prayer clause 1, page 9. Paragraph, nowhere in the petition has it been indicated what is the precise amount owing to each of the 16 petitioners by the opposite party OSRTC. Full stop. It is not possible, therefore, for this court to even issue any precise directions in that regard. Full stop. Despite notice having been issued way back on 21st November 2012, no counter affidavit has been filed. In fact, today none is appearing for OSRTC. Paragraph. Since there would obviously be disputed questions of fact vis-a-vis the dues owing to each of the petitioners, it is not possible for this court to entertain the present petition to examine the above issue. Full stop. The better course of action is to require OSRTC to examine the representation made by the petitioners Annexure 2 series, give them a hearing, and pass appropriate orders vis-a-vis the dues, if any, owing to each of them, and thereafter disburse the amounts in accordance with law. This entire exercise be completed within a period of 3 months from today.
Right. That will do.
The petition is disposed of in the above terms.
Weekly list item 29.
Which are the other 3 matters, sir?
My lord.
All right.
Item 29.
Challenging the cancellation of lease, my lord. Previously, the petitioner with the purchaser had filed a writ petition bearing number OJC number 2764 for 1998, and the matter disposed of 6398 and remanded the matter was the order and remanded the matter to the ADM to file a show cause by 6/4/1998. Accordingly, though I have filed my show cause on 6/4/1998, the matter is sub judice before the ADM. I pray the direction be given to the ADM to dispose of that matter.
So this writ petition has nothing to do with that 1998 matter at all. This is implement the order.
The second
writ petition to implement an earlier order
of 1998.
98.
And another
because
thing
contempt and all is gone.
That's because there is no time limit, my lord.
So 14 years you wait.
Because the matter
to implement an order of 1998, you wait for 14 years, file another writ petition.
Because the matter is sub judice before, my lord, the case is
And another thing I want to point out, your lordship, the ADM has cancelled the lease in 1987. He has purchased it in 1998. Next, after.
Anyway, this court seems to pass an order on 6398. All right. This writ petition has been filed seeking implemented on 30th July 2012. seeking implementation of an order dated 6/3/1998 of this court that is passed more than 14 years earlier. Full stop. It is claimed that the ADM is still seized of the matter in revision case number 83 of 87.
Yes.
It's still pending in the ADM.
Yes.
You're absolutely sure.
Yes, that is pending, my lord.
I have no instruction. Your lordship may.
Counsel, the petitioner states that the state case of the before the ADM is still pending. Paragraph. There is counsel for the state, on the other hand, has no instructions. If the above case has not yet been disposed of, it should be disposed of within a period of 6 months from the date of production of this order, of a downloaded copy of this order before the ADM by the petitioner. All right. The petition is disposed of.
Equally item 30.
My lord, no instructions.
Counsel, the petitioner states he has no instructions. Disposed.
Equally item 31.
My lord, I am for the other side, my lord.
It is stated that the petitioner is before the NCLT, Calcutta bench, in CPIB number 250/KB/2021. Consequently, it will be open to the parties to approach the NCLT for appropriate reliefs. The petition is disposed of.
Equally item 32.
None appears dismissed or not possible.
Equally item 33.
Your lordship, item 32.
Yes.
Your lordship, may kindly pass out the matter on behalf of learned my senior TK Satpathy, Tushar Kanti Satpathy.
Whom is he appearing for, sir?
UGC, your lordship.
No, this is 32.
Sir, this is for the petitioner or for the opposite party?
This is a revenue matter. There is
opposite party number 2, your lordship.
Yeah, we have now dismissed it for non-prosecution for non-appearance of the petitioner, sir.
I think he is not mentioning item 32. 32 is something else.
What is the petition you are appearing in? Give us the number of the petition.
Item number.
Sir, item number we are not asking, petition number we are asking you.
He's saying about some UGC, but here UGC is not a party, it's collector. That is, I think, 35.
Quickly is 33.
Counsel to the petitioner has filed a memo saying he has no instructions. Petition is disposed.
Quickly is 34.
None appears disposed. No.
Quickly is 35.
35, your lordship. I'm appearing on behalf of the petitioner, your lordship. This matter is covered by your lordship's judgment.
Okay.
I've given a copy of it, your lordship, by way of a memo. It's the same demonstrator matter, your lordships.
All right.
I think that's the matter which the council probably was mentioning, was UGC's party there.
Oh, I see.
No. But it's anyways covered, your lordships.
Who is for the other side?
If you like to, well, I am appearing for the state. It appears that notice was issued directly to the opposite party state. And noting is that it is not received from the opposite part number 1, 3, and 4.
No, but you are there, sir.
You let me grant me some time. I'll.
No, it's already covered by the judgment.
Yes, I have.
In fact, this is ditto the same writ application, word by word, your lordships. The one your lordships have.
No, but have they challenged this judgment? Are you aware?
But to my information, till date, they haven't. In fact, other benches have also taken note of this judgment.
Just now I have received a copy of the judgment. I will obtain instruction whether it is challenged or not.
Mr. Mudli himself was arguing that matter.
Monday, your lordship call
this matter so that in the meantime,
the present petition is covered entirely in favor of the petitioner stands covered in favor of the petitioners by the judgment dated 18th April 2022 of this court in WP Civil number 26692 of 2011, bracket Samarendra Nayak versus Union of India. Mr. Murli, appearing for the state, seeks time for instructions. 26th July.
Weekly list item 36.
Memos taken on record. Dismissed as withdrawn.
Weekly list item number 37.
But I am for the petitioner, there is no instruction in this matter.
Counsel petitioner states he has no instruction. Dismissed now.
Weekly list item number 38.
No instructions, my lord.
No instructions. Dismissed.
Weekly list item number 39.
Memos taken on record.
Of this case, my lord.
Dismissed as withdrawn.
Weekly list item number 40.
No, please. Dismissed and not prosecution. Stay or interim orders.
Weekly list item number 41.
Wait, please, my lord. My lord. The petitioner impugned the order at Annexure 3, that is the order of the administrator of Lord Jagannath Mahaprabhu administration, wherein the one Mudra Seva is there of the Sevayats. The administrator made 10 days Mudra Seva in favor of the opposite party. That was impugned by one of us. In the meantime, my lord, what I submit that the matter is pending before the learned civil court as regard to the same cause of action.
All right. So you withdraw this petition, sir?
Yes, my lord.
For the petitioner?
Yes, my lord.
Counsel, the petitioner states that since there is a civil suit already pending between the parties regarding the same cause of action, he wishes to withdraw his petition with liberty to pursue the remedies in the pending proceedings.
Your lordship.
My lord, I am for the intervention petitioner, my lord. The civil suit is pending from 1984, my lord.
Right. So he wants to withdraw this petition, sir.
In spite of repeated orders and directions of your lordship, I am the plaintiff in this case. Civil suit is not proceeding. Your lordship may kindly say that they are not.
Yeah, it will be open to the parties to approach the civil court for expeditious disposal of the pending civil suit.
Your lordship, another observation may be there. The impugned order, it says that the order itself is subject to the result of the civil suit. In that case, my lord, if I withdraw, that the order, whatever will be there, that will be the civil suit, that may be subject to this order may be subject to the suit, because the order itself, impugned order itself says that this will be subject to the result of the suit.
Correct.
That I'm withdrawing this writ petition.
Yeah, so we have not said anything, sir. It's disposed of as withdrawn with liberty is paid for. That's it. All right.
Weekly list item 42. Item number 42.
None appears to be.
Weekly list item number 43.
The matter is becoming infructuous.
Counsel, the petitioner states the petition has been rendered infructuous. It is disposed of as such.
Weekly list item number 44.
None appears to be non-prosecution.
Item number 45.
None appears to be non-prosecution.
Weekly list item 46.
May I please, your lordship? On behalf of Mr. Lal, I may be permitted to place this one. Your lordship, this writ petition was filed challenging two orders. Order dated 11/12/2012 and order dated 5/2/2013 passed by the Labour Court, Sambalpur. Your lordship, to that respect, I am filing a small written note and certain judgments.
Yes.
Your lordship, with respect to the first order, that is 11/12/2012, that has been declared ultra virus. The order is relating to section 36(4) of the ID Act. The
Yes.
Your Lordship, the judgment was passed by this Honorable Court on 13/5/2022, but it's yet not uploaded, so I couldn't produce a copy.
How come? Which is the writ petition?
Writ petition number 20,007 of 2013.
Okay. Just see that.
Your Lordship, it was passed by the bench of Honorable Justice Biswajit Mahanti and Honorable Justice Birija Satpathy.
You have a copy?
I don't have a copy. It's not yet been uploaded.
No. What is the date of the disposal, you said?
Disposal date was 13/5/2022.
No. Call for the file. We'll pass it over. Just call. What is the number?
20,007 of 2013.
Yeah.
WPC.
Call for the file immediately. We'll pass it over. Let the file be called.
Obliged.
I think we'll call it at 2 o'clock. By then the file would have.
Yes.
Also ask for an explanation why it's not uploaded.
Weekly list item 47.
47 may I please listen? I'm in virtual movement. My in that case, my lordship, my annex 2 is pending before opposite pen 2, my lordship.
The Annex 2, nothing's there to show it was even delivered to the collector, sir. Just some handwritten, you make a fresh representation. There's nothing to show that Annex 2 was ever delivered to the collector Kendrapada, permitting the petitioner to make a fresh representation to the collector if any cause of action survives, the petition is disposed of. Right.
Weekly list item 48.
None appears dismissed for non-prosecution.
Weekly list item 49.
None appears dismissed for non-prosecution.
Weekly list item number 50.
50 may have lordship. In this case, my counter affidavit has been filed by the opposite pen 2, my lordship.
What's the matter about, sir? Tell us. No. Tell us what the matter is about.
In that case, my lordship, the present person challenging the illegal and arbitrary order of the my lordship, which is annexed in Annex 3, my lordship. Page 12, my lordship. That BMC, that order of the BMC, my lord, Bhubaneswar Municipal Corporation has a challenge, my lordship. Corporation not giving me permission to plantation and greenery in front of the vacant strip of the government land of the opposite pet, my lordship.
So what is wrong in planting greenery? What's your problem with planting greenery, sir, opposite the government land? What's your problem? What is your problem, sir?
My lordship.
That has been stayed with this court for 10 years now. What is the legality here?
That land has been allotted, mutated on the name of the present petition, my lordship.
Where does it say that? Government land?
In Annex 1, my lordship. That the lease deed has been executed, my lordship, with the present petition, my lordship.
But no permission is given as far as your land is concerned, sir.
That, my lordship, I only an adjournment, my lordship. I will take.
No need. Note for adjournment, sir. When was this counter filed?
Yes, OP number 2 has already filed the counter.
2015 itself. You say the counter affidavit filed on behalf of OP number 2 way back on 18 July 2015. It has been clarified.
Paragraph 10
in
page 3, paragraph 10.
That in para 7 as under reproduce para 7. In view of the above clarification, which has not been countered by the petitioner by filing any, which has not been contradicted by the petitioner by filing any rejoinder till date. There is no merit in the present petition and it is dismissed as such. The interim order is vacated.
Weekly list item 51. Item 51.
None appears dismissed or not.
Weekly list item 52.
No instructions received, Your Lordship.
Counsel for the petitioner says she has no instructions. Dismissed as such. Both matters.
Weekly list item 53.
May please, Lordship. Here the petitioner challenges the demand notice has been issued on the basis of transport fee. This is covered by a judgment of this own court. Here the transportation has not been made, and by audit objection they have raised that you'll have to pay the transport fee.
Lordship may direct the commissioner to examine this judgment. If it is covering, then
all right.
Commissioner will take care.
Counsel for the petitioner relies on a judgment dated 18 July 2016 passed by this court. In writ petition civil 4552 of 2010 bracket Sunil Kumar Jaiswal versus State of Orissa, and states that the present prayers in the present petition stand covered by the said judgment. It is seen in that the said judgment in turn refers to an earlier judgment dated 19th September 2014 in writ petition civil 14493 of 2004. Paragraph: the commissioner
Excise
will examine the present petition in light of the above judgments and after hearing the petitioner pass an appropriate order not later than 12 September 2022.
The petitioner will appear before the commissioner.
Petitioner will appear before the commissioner for the above purpose on 11th August at 3 p.m. along with a downloaded copy of this order. Copy of this order be also sent forthwith to the excise commissioner.
Both the matters, sir. Both the matters, sir.
Yes. The petitions are disposed of in the above.
Weekly list item 54. 54.
None appears dismissed on opposition.
Item 54.
Item 54, I am for the petitioner, no instruction, my lord.
Counsel petitioner states he has no instructions. Dismissed.
Item note 55.
None appears dismissed on opposition.
Item note 56.
56, I am for the OP1, my lord.
All right. None appears for the petition.
Matter has been settled and the petition has become infructuous.
Item 57.
May pardon, my lord. This is 2013 matter. File not available. Tomorrow or day after tomorrow, my lord.
No. You say counsel for the petitioner states the file is not available. The petition is dismissed on non-prosecution with liberty to the petitioner to revive it in case he is able to locate the file.
If file is available.
Correct.
Weekly list item 58.
Here, brief has been transferred. No. I have no power.
Counsel the petitioner says the brief has been transferred. None appears for the petitioner. Dismissed on non-prosecution.
Weekly list item 59.
Interim order vacated.
Item not 59.
No instructions. Dismissed.
And my lord.
Interim order is vacated.
Weekly list item 60.
My lord, no instructions. No instructions. Dismissed for non-prosecution.
Weekly list item 61.
My lord, I am for the petitioner, my lord.
Yes.
This matter has infructuous, my lord.
Counsel the petitioner states the petition has been rendered infructuous. It's disposed of as such.
Weekly list item 62.
None appears dismissed from non-prosecution.
Weekly list item 63.
Your Lordship. May I please, Your Lordship? Your Lordship, the question of law has already framed. In this case, two questions of law have been framed by the order dated 9th January 2013. Whether in the facts and in the circumstances of the case, the Orissa Sales Tax Tribunal aid in law by deciding the second appeal of the dealer on merit, especially when it has remitted the matter back to the assessing authority of range on the ground that the assessing authority of the circle had no jurisdiction to take up the assessment under Odisha Evaluated Tax Act. And so for a second question, whether in the facts of the decision reliance placed on the decision, Your Lordship rendered in the state of Odisha magnum so-and-so, Your Lordship, this is the question of law. Now, Your Lordship, so far as the first question of law is concerned, the matter has been remitted back to the assessing officer. So that question of law may not be important, Your Lordship. Your Lordship may kindly turn to page 20 of the, running page 20, page 3, internal page 3 of the OSTT orders, Your Lordship.
Yes.
Your Lordship, 4 to 5 lines below, now coming to other aspect. Whether the said Dantamanjan Lal is accessible to tax at the rate of 4% of the group, or it will be 12.5% of tax group. In this context, we may cite the reported judgment of division bench of this tribunal passed in essay number so-and-so, wherein detail it was held that difference between the definition of care and cosmetic in our considered opinion, even though Dantamanjan Lal is not sold on medical prescription, but it is an Ayurvedic medicine for the gums and teeth. So it is only accessible to 4% tax group. Now, Your Lordship, I may be permitted to produce two judgments, Your Lordship. Your Lordship, in this honorable court in Dabur India versus Commission of Sales Tax, one and another, Your Lordship, Honorable Supreme Court, the Central Excise judgment has passed in favor of the revenue, Your Lordship. So far as the first judgment in this honorable High Court has decided the case that petitioner claimed its product, a toothpaste, an Ayurvedic medicine chargeable to sales tax at the rate of 4% as an item 7037. Commissioner charged it at rate of 12% as provided in residual items 105. Petitioner appeal rejected, hence present petition. Your Lordship, the operative portion, Your Lordship, at paragraph 7, internal page 3, paragraph 7.
It's not a drug and therefore.
Your Lordship.
All right.
So it is a customer, and also Honorable Supreme Court in the same goods, Lal Dantamanjan.
Right.
It has been decided that it cannot be Ayurvedic medicine.
Right. All right. Yes, what do you say?
My lord, subsequently, the Honorable Tribunal, relying on the subsequent judgment of the Supreme Court, where the Supreme Court, Honorable Supreme Court has, in these two judgments, I'm placing the judgment, my lords, that if the products are sold under the medicine drug license, and even if minimum material are there, of some Ayurvedic material are there, it can be eligible as a...
No, but this judgment is your own matter. This Supreme Court judgment is your own matter.
Yes,
by the clearly says this Dantlal Manjan is a drug.
But subsequently, my lords, the test which
is not a drug. Sorry,
is not a drug.
Not a drug.
This is a previous judgment, my lords. Subsequently, a judgment in Puma case, my lords, two tests has been laid down by the Honorable Apex Court, but to see whether
we are on your own product. This very product, the Supreme Court judgment. Once there is this very product is held not to be a drug but a cosmetic. You can't go behind that. We say two questions have been framed by this court for consideration. By the order, the following two questions have been framed for consideration by this court by an order dated 9th January 2013, while admitting this revenue petition of the revenue arising from an order dated 19th November 2011, passed by the Orissa Sales Tax Tribunal in essay number 162 of 2009-10. Full stop. Colon, and then replace the two questions in that order. Paragraph, as far as the first question is concerned, it is pointed out that by the impugned order, the tribunal has itself remanded the matter to the assessing authority to make a fresh assessment. And therefore, the first question may not be of relevance any longer. Paragraph, as far as the second question is concerned, Reliance has been placed with learned Mr. Sunil Mishra, learned standing counsel for the revenue, on the judgment of the Supreme Court in Sri Baidyanath Ayurved Bhavan Limited versus Collector of Central Excise Nagpur, 1996, 9 SEC 402, where the very product in question, namely Lal Dant Manjan toothpaste, manufactured by the respondent SSC, Dant Manjan Lal, not Lal, Dant Manjan Lal, manufactured by the respondent SSC, has been held to be not a drug not a medicinal preparation. Stop. The observations of the relevant portion of the said judgment reaches under due to the whole of para 3, A to A. Paragraph. Since the above judgment is in the very product with which the present petition is concerned, namely Dant Manjan Lal toothpaste, the aforementioned question is answered against the SSC and in favor of the department. So now that remand will be unnecessary.
Not required.
In view of the above conclusion, the remand ordered by the tribunal to the assessing officer becomes unnecessary. Full stop. The impugn order of the tribunal is accordingly hereby set aside. The revision petition is disposed of. Here, this also.
Weekly list item 64.
Your Lordship, item number 64, there is a delay of 104 days and also paltry amount 29,000.
All right. The delay not explained, the application is dismissed. In any event, the tax amount is insignificant. Questions of law are accordingly left open. The petition is disposed of.
Weekly list item 65.
Your Lordship, the question of law is at page 9 of the brief, Your Lordship. Whether in the facts and in the circumstances of the case, the full bench of Orissa Sales Tax Tribunal is justified in concluding that if packing material are purchased by paying entry tax, the same has to be deducted from the sale price on the face of admission by the dealer that it has collected entry tax on packing material from the buyers and therefore correctly relied on the decision reported rendered by single bench of Orissa Sales Tax Tribunal in the matter of Oriclean Private Limited versus State of Orissa, Your Lordship. Now, Your Lordship may kindly turn to the tribunal's order. At page 38, running page 38, Your Lordship, 3 to 4 lines below. Now coming to the appeal preferred by the dealer, it is forthcoming that the dealer claims that the purchase of packing material and payment of entry tax be deducted from the sale price of paper and paperboard. If the packing material are purchased by paying the entry tax, the same has to be deducted from the sale price to determine the liability of the dealer. There is the cited order passed in SN number so of this very tribunal. We do agree that the entry tax paid on purchase of packing material has to be deducted from the sale price of the paper. Now, Your Lordship, I have enclosed that tribunal's order itself, which has been cognized by the tribunal. That is a different aspect, Your Lordship. Your Lordship may kindly turn to page 20.
No, but irrespective of that, what is wrong with this proposition that entry tax has to be deducted?
Well, my Lord, what is the definition of the entry tax paid? If entry tax paid, that can be deducted from the sale price of the... So that is important, Your Lordship.
No, but why tax on tax? If that entry tax component is being asked to be deducted from the sale price, what is wrong with that?
Your Lordship, at page 6 of my brief, I have clarified that.
No, only ground is that the other judgment does not cover this. But what about the merits itself? What is wrong with it? We won't interfere as the revenues in appeal. The revenue has filed this revision petition.
Your Lordship, let the question of law open.
Why?
Your Lordship, because there are some disputed fact, Your Lordship, at page 30, whether that entity tax paid or not.
Anyway, the tax effect is 24,196.
No.
That's it. It's only 24,000, sir.
No, Lordship.
First paragraph.
24 lakhs. Oh, sorry. The appellant is therefore required to pay 3,04,955.
No, just come to the impugned order of the tribunal, page 40, first paragraph.
No, that is, Your Lordship, different order. That has been cognized by the tribunal. That order has been cognized by the tribunal.
I see.
And allowed the.
Then we might as well say the revenues has challenged the order dated 8 May 2013, passed by the Orissa State Sales Tax Tribunal, allowing the SEC's appeals essay number 245 bracket ET of 2006-07 and essay number 281 bracket ET of 2006-7. Appeal passed in appeals filed both by the SSC and in the revenue in essay numbers 245 bracket ET and 281 bracket ET of 2006-7 respectively. The questions ought to be urged for consideration by this court, by the revenue, is whether the entry tax component paid on the packing material used by the SSC has to be deducted from the can be deducted from the sale price, question mark. In the impugned order, while answering the question in favor of the SSC and permitting such deduction, the tribunal has relied on an earlier order dated passed by the tribunal in essay number 85 bracket ET of 2004-05 on 22nd May 2006. Full stop. Paragraph Mr. Mishra contends that the said order dated 22/5/2006 is on an entirely different aspect and was not relevant for deciding the issue in hand. Paragraph. However, on merits also, the tribunal has come to the conclusion that the entry tax paid on the packing material purchased by the SSC cannot be subject again to tax at the point of sale. And to that extent, the entry tax component was deductible from the sale price. Stop. The court is unable to find any error having been committed by the tribunal in coming to the above conclusion. Consequently, no substantial question of law arises. The revision petition is dismissed.
Weekly list item 66.
None appears dismissed now.
Weekly list item number 67.
67, Your Lordship. 67 is the parametria provision. So far as that 40-5 penalty is concerned, Your Lordship. Audit assessment, Your Lordship, has already passed the judgment. So far as the audit assessment.
Yes, I am item 66.
Carry on. We called it out, sir. Tell us what it is.
66 was called.
Yes, sir.
And so the tax revision, because the order of the tribunal.
Yes.
The matter relates to an entry in the schedule of sales tax, Orissa Sales Tax Act. Question is the tin container. What is tin container? I manufacture mild steel drums, which are tin containers. But the assessing officer has taken a very hyper-technical view that it should be manufactured out of the metal tin. And that is not the common parlance meaning of tin container. Tin cans, tin containers, tin sheds, tin sheets. This means it is manufactured made of iron or steel and tin coating is given on it. That is the common parlance meaning. Now the question of law that I framed. And in another year, the subsequent year, it has been taken under that entry and taxed at 4%. But in this year, it has been taxed under the residual entry.
No, next year when it was taxed under the entry for tin containers,
yes,
that has not been challenged by the revenue.
It has not been challenged by the revenue.
No, that short ground we can allow it.
Order is at Annexure 8, my lords.
All right. That's the assessment order.
Yes, that is the assessment order in which it has been taxed under that entry. Lordship may see the entry, it's at page 24 by notification.
No, this assessment order you have taken us to Annexure 8. Page 36.
Yes, Your Honor. In this assessment order for the subsequent year, it has been taxed under that entry of packing material. And
where do you get that? Where do you get that? Which page?
Space 37, as the order continues. So at the end, no discrepancy has been noticed at the time of examination of accounts, as the account return figures accepted and assessment completed accordingly. Out of the taxable amount of rupees so much, the dealer has claimed sale against Form 4 for 2,41,542 and submitted the valid declaration in Form 4.
No. Where do you get this, sir? That this has been treated as that under that entry and all that?
Yes. I'm coming to that. I'm coming to that. No. Please let me place. I am the petitioner. Which is verified and found correct and hence accepted. The balance amount of 21,14,631 is taxable at the rate of 4% as per serial number 129 of list C of the rate chart. Now, this is the entry, my lords. Entry in the schedule, list C of rate chart, serial number 129, 4%. Accordingly, the GTO stands determined at 24,59,485. After allowing deduction of so much towards STC, the TTO stands determined at so much, taxed at the rate of 4%. Again, declaration Form 4 machinery and 4% on rupees so much packing materials, that is MS drum. This is the container that I manufacture as per serial number 129 of list C of rate chart. Calculated comes to 94,247. Here he has taxed it at 4%.
It says packing material, that is to say gunny bags, HDPA bags, corrugated bags. Okay, tin containers.
I'm only manufacturing tin containers.
All right. You say this is an assessee's revision petition against the order dated 14th May 2013 of the Orissa Sales Tax Tribunal in essay number 1148 oblique 2005-06. By the impugned order, the tribunal allowed the state's appeal against the order dated 19th May 2005 of the Additional Commissioner, Assistant Commissioner of Sales Tax, bracket ACST, Sundargarh Range, Rourkela, in AA 406, bracket RL-2 of 2004-05, and restored the assessment order dated 30th October 2004, passed by the assessing officer for the assessment year 2003-4. In sum, the tribunal agreed with the assessing officer that tin containers sold by the petitioner were exigible to sales tax not under entry 129 of list C appended to the rate chart. No, list C of the rate chart appended to the Orissa Sales Tax Act 1947 bracket OST Act. But under the residual entry, where the rate of tax was 12%.
12%.
Paragraph. While admitting the present petition on 5th August 2014, the following questions were framed by this court for consideration. Paragraph. At the outset, counsel for the SEC points out that for the subsequent year, that is 2004-05, the assessing officer has accepted the plea of the SSC that tin containers are classifiable under entry 129 of list C appended to the list C of the rate chart. Appended to the OST Act, which reads thus: reproduce entry 129. This flag is here, the book. From the copy of the assessment order for 2004-05, it is evident that the tin containers have been taxed at 4% and not 12%. Full stop. That order has not been further questioned by the revenue. Full stop. Since for the subsequent year, the plea of the SSC, the above regard has been accepted, there's no reason why, even on the principle of consistency, it should not govern the earlier year, that is 2003-04. Paragraph. There is merit in the contention of the counsel of the SSC that the expression single quote tin containers is to be understood in common parlance in normal commercial trade practices. And it would be wrong for the department to insist that only containers manufactured entirely out of tin should be considered as tin containers.
Here, whether
the essential character of the container being that of a packing material, and in the trade and common parlance, it is in effect a metal container with a coating of tin. There is merit in the contention that it is classifiable under entry 129 of list C of the rate chart appended to the OST Act. Paragraph. For the aforementioned reasons, the questions framed by this court are answered question number 1 is answered in the affirmative in favor of the SEC and against the department. And question number 2 is answered in the negative, that is in favor of the SEC and against the department. The impugn order of the tribunal is hereby set aside. The tribunal as well as the assessing officer are hereby set aside. And the order of the ACST is restored to file. The petition is disposed of in the above terms.
Item 67.
Your Lordship, Your Lordship, item number 67, that is the penalty. Your Lordship, the question of law is at page 15. Whether on the facts and circumstances the case, it is not justified in affirming the order of first appellate authority, wherein the penalty imposed under section 9C5 of Orissa Anti-Tax Act has been deleted. Now, Your Lordship may kindly turn to the tribunal's order. Your Lordship,
what's the value here, sir?
Your Lordship, value is much more. Now, that is 2,31,000, 31,834. Your Lordship, that Your Lordship has already passed the judgment.
No, but no notice has gone in this. Without notice to the other side, how do we do it?
So it is covered by Your Lordship judgment. That audit
All right.
assessment, no pen, there is no
returnable.
penalty.
All right. Notice returnable 13 September.
Weekly list item 68.
Yes, the answer is covered by Your Lordship order dated 6/7/2022. Same questions have been answered. Regarding anti-dating and
Say, in view of the order dated 6 July 2022 in STREV 100 of 2013, the present petition is disposed of in the same terms.
Weekly list item 69.
None appears dismissal not possible.
Weekly list item 70.
None appears dismissal not possible.
Weekly list item 71.
None appears dismissal not possible.
Weekly list item 72.
None appears dismissal not possible.
Weekly list item 73.
173, I am for the bank. The matter was disposed of, but the writ petitioner in the meantime in 2018, he is deceased and now we had filed a substitution petition. So now this miscase has abated.
All right. In this case, you say in view of the subsequent developments, this application is abated and it's disposed of.
Miscase copy I'm giving which we had filed in the DRT that the petitioner is.
All right.
Weekly list for orders item 74.
May I please, Your Lordship? This relates to an order under section 19 of the OHRE Act, Hindu Religious Endowments Act. And my limited grievance is permission has been granted. And the government in appeal and religion, government has also concurred. My limited grievance is I am a tenant in respect of that land. So I may be permitted to take that land at that price instead of a public auction.
Why?
There is no preference.
Annexure 3 at page 12, Your Lordship may kindly see. I am a tenant paying sanja, paying rent regularly for the last 45 years.
Why shouldn't take it at market rate, sir? What is the special
You can
preference?
participate in the auction process.
But I am there since 45 years.
So what, sir?
So
is there a statute? Is there a rule which permits you to give first preference or something?
No, there is no preemptive right.
No rule that.
No right of first purchase. Nothing like that.
No, in that rate I will take.
Why should you? Why should you not participate in public auction? In fact, now you've invited more trouble for yourself. You got the state for 10 years. Now you'll not be able to compete. This must be extremely valuable land. The short ground on which the petitioner sought to stall the sale by way of a public auction of the land in question by the Commission of Endowments is that he's been a tenant in the land for a long period of time and that he should be permitted to purchase the property at the market value at that point in time.
Rate fixed by the government.
At the rate fixed by the government at that point in time. Paragraph. As has been pointed out by learned additional government advocate, Mr. Mounty, there is no rule, instruction, circular, or even provision under the OHRE Act that an existing tenant would be given the right of first purchase without having to participate in a public auction. Paragraph. Without there being any such legal basis, for the relief sought, the court is unable to accede to the prayer of the petitioner. Full stop. It will always be open to the petitioner to participate in the public auction which will hereafter take place. Paragraph, the interim order dated 13/12/2012 is hereby vacated. The petition is dismissed. No orders is to cause.
My lord, this judgment may be communicated to the endowment commissioner because
a copy of this order be sent forthwith to the Commissioner of Endowments.
But the original petitioner died, substitution application that may be allowed so that the legal heirs
First, you say that IA is allowed. The substitution as prayed for is allowed. All right.
List item 75.
May not permitted to withdraw this application.
Counsel, the petitioner seeks to withdraw this petition. Dismissed as withdraw.
Appearance of the opposite parties by order. And may I have a prayer, my lords? A copy of the memo may kindly be served on us for our record sake.
Please serve a copy, sir.
Yes, I'm sure.
Weekly list for admission item 76.
76, my lord.
The matter has become infructuous.
Counsel, the petitioner states the petition has become infructuous. This post office.
Weekly list item 77.
My grievance is that opposite party number 4 should not be given the benefits of the scheme.
What scheme?
There is a Mokuria scheme, that is Annexer 5. Annexer 5 is a scheme by which the government has decided that all the thatched houses should be made concrete and good houses. Under the scheme, they provide 70,000 rupees to.
So why are you agreed by opposite party number 4?
My house. That is my house. It was willed away in my name. Suit is pending, and opposite party number 4 saying as if he is the owner.
So you should ask this relief in the suit.
My lords, if I may.
You should ask this relief in the suit, sir. Then
no, that relief. I have already filed the suit and suit's injunction order. I would invite your lordships to page 58 for 1 minute. That is the deposition of the opposite part number 4 in the suit at page 58, paragraph 11. The lords got it. I demolished the suit house so that I can get a house under the Indira Awas scheme. I am staying in the rented house.
So what will happen under the impugned scheme? What will happen?
He will be provided some money by the government. By that gives an acknowledgement to him that as if he is the owner,
Nothing.
And he can
have a suit. Obviously, it will be subject to the outcome of the suit, sir. If there's already a suit, it will be subject to the outcome of the suit. The present petition has been filed for a direction to the opposite party state not to provide any benefit to opposite parties 4 to
4.
No. 4 to. There are so many people, sir. 4 to 9. You put some 5-6 people there. 4 to 9 under the Mo Kuria scheme, as per the resolutions dated 9th May 2008 and 9/6/2015 of the government of Orissa. Stop. According to the petitioner, he has already filed a civil suit in which the opposite parties aforementioned are the defendants. And a statement has been made by the opposite parties in the said suit to the effect that the house property to which the petitioner is laying claim was demolished by the opposite parties, and they would be approaching the government for benefit under the Mo Kuria scheme. So the apprehension is that if the government grants any benefit, financial benefit for construction of a house under the Mo Kuria scheme, then it might legitimize the claim of opposite parties 4 to 8 paragraph. The court does not find any merit in the above submission. Since the civil suit is stated to be pending, any such financial grant to opposite parties 4 to 8 by the government under the aforementioned scheme would obviously be subject to the outcome of such suit. Full stop. In any event, appropriate interim reliefs in that regard can always be sought by the petitioner in the pending suit. Full stop. In that view of the matter, the court sees no reason why the release prayed for in the present petition should be granted. The interim order is vacated. The petition is disposed of with the above clarification.
Weekly list item 78.
None appears dismissed on all prosecution.
Appearance of unanimity noted by.
Weekly list item number 79.
Item 79, my lord, and the matter has become infructuous.
Infructuous, it is disposed of as such.
Appearing for the municipal corporation.
Weekly list item 80.
None appears dismissed on not.
78 and 80 appearance of unanimity noted by.
Right.
Weekly list item 81.
The memo is taken on record. Dismissed is not pressed. Yes, infructuous. Disposed of is infructuous. Correct.
Weekly list item 82.
None appears dismissed, not prosecution.
Weekly list item 83.
None appears dismissed, not prosecution.
Weekly list item 84.
None appears dismissed, not prosecution.
Weekly list item number 85.
None appears dismissed, not prosecution.
Weekly list item number 86.
None appears dismissed, not prosecution.
Weekly list item number 87.
87, 88 in purchase.
87, 88 disposed of as infractions.
Weekly list item number 89.
None appears dismissed, not prosecution.
Weekly list item number 90.
None appears dismissed, not prosecution.
Passport. Weekly list passport matter item number 13.
May it please, Your Lordship. Your Lordship, this is the challenge with regard to the award dated 17/9/2011, which is at Annexer 7, page 29, passed by the Labour Court, Bhubaneswar, Your Lordship.
Yes.
Your Lordship, this 13/12/1978, the opposite party is the workman. He joined as a supervisor on temporary basis. And that was extended from time to time. On 31/8/1979, Your Lordship may come to Annexer 1, page 11. He was appointed temporarily for September 1979. Your Lordship sees for 1 month only. Page 11.
Yes.
Yes. He was appointed along with others. He appointed for only 1 month only. And thereafter, Your Lordship, on the next page, that is Annexer 12, Your Lordship, this 26/9/1979, that by this notice, he was directed to be terminated with effect from 1/10/1979. That is Annexer 2.
Yes.
This has not been challenged at any time by the workman, Your Lordship.
Right.
And then, Your Lordship, on 27/12/79, that is Annexer 3, page 13, he was freshly appointed. This opposite party was freshly appointed. This Ganeshwar Sahu, he was freshly appointed, and he also joined. That is Annexer 3, page 13, Your Lordship. And thereafter, he continued, Your Lordship. So this date is important, 27/12/1979. This is the appointed date for all purposes, Your Lordship. Then in the next page, Your Lordship, Annexer 4, that is a gradation list which was published on 25/9/1985, Your Lordship. Your Lordship finds at page 16, 16, Your Lordship. This gradation list of supervisors and sub-accountants, Your Lordship finds it. The name of the opposite party is at number 16, Ganeshwar Sahu, 16. Your Lordship finds third before the end, Your Lordship, bottom.
Yes.
And Your Lordship may kindly mark serial numbers 2, Bhagirathi Marana, Sarat Chandra Pani, there are 2, 3, 4, 5, 6, and 7. Because these names are important in this case, Your Lordship. These 6 persons have been shown senior to him. This has not been challenged by him at any point of time, Your Lordship. Then, Your Lordship, on 9/12/1989, there was a second gradation list published by the bank, which is admitted by the workman, which is at page 20, Your Lordship. Page 20 of his written statement before the Labour Court, Your Lordship.
Yes.
Page 20, Your Lordship, para number N, Your Lordship. N. Internal page 4.
another draft gradation list on 9/12/1989, where the workman was placed at serial number 57. Your Lordship. And thereafter, Your Lordship, the next page, page 21, the third gradation list, that is another final gradation list, was published on 18/8/1997. That is at para R, top para, Your Lordship.
Yes.
Of that page, Your Lordship. 18/8/1997 finalized the final gradation list. This also has not been challenged, Your Lordship. And thereafter, on 26/10/1998, he raised an industrial dispute, Your Lordship, before the district labor officer. And on 9/2/2006, Your Lordship, marks 9/2/2006, that is after 21 years, the reference has been made, which I have quoted at page 4 of my writ petition, Your Lordship. I'm sorry.
How old is he now, sir?
My Lord, he must be 67, 68, Your Lordship, by now. Your Lordship.
So what is the relief granted?
Relief granted is that his seniority will date back to 1985, Your Lordship, when the other persons were promoted, and he will get all his benefits. And Your Lordship, why I am placing this case, because
He's not even a workman.
My Lord?
You're accepting he's a workman or he's a supervisor?
Yes. No, workman is apart. Workman is no dispute. What the learned court has done, the reference, Your Lordship, may kindly have a look at the reference, Your Lordship. Page 4.
No, but who's appearing on his behalf then?
My Lord?
Somebody should be appearing on his behalf.
Mr. Baral, I think I noted that Mr. Bamdev Baral is the workman appearing before him. He has said that because he was illegally terminated prior to his date of appointment, so that appointment or termination was wrong, so he should be continued in service. And on that basis only he has given the relief. But then that is not a subject matter of the reference. And Your Lordship knows, and in many cases Your Lordship also led, that tribunal or labor court cannot exceed the terms of the reference. That is
So he has got relief from 79 onwards?
Yes.
Oh.
Not 79, 78, Your Lordship, prior to his appointment.
Whereas the reference is only from 9/11/85.
Yes.
So you have no grievance if it is from 9/11/85?
No, 9/11 he cannot be, because he has not challenged that. The promotion orders he has not challenged. And he has not challenged the subsequent gradation lists also, where the promotees are.
Where is the counsel, Mr. Baral?
He is not there. Your Lordship, if Your Lordship feel it convenient, Your Lordship may fix it to some other date. So I can also inform him.
On the second call, Mr. N.K. Mishra and the senior counsel appears for the petitioner and makes his submissions. However, none is appearing on behalf of the opposite party workman, even on second call. Notice without process fee without be issued by the registry to Mr. Bamdev Baral, then at counsel to remain present in court on the next date. In the interest of justice, list on 29th August.
29th. Yes, grateful.
Pastor matter item number 27.
The interim order is there to continue.
Yes, interim order cut.
Yes, grateful.
May I pardon, my lord? My lord, item number 89.
1 minute, sir. Let's finish this and then we'll take up others.
Item 27.
My lord, your lordship wanted me to take instruction whether he can deposit. I have an instruction he can deposit. Let me clarify only one thing. That 60 lakhs amount of Mr. Acharya with interest I will pay. But that 60 lakh has been appropriated by the OSFC, who has to also adjust towards the loan account.
No, but you're now claiming that they could not have adjusted. So
no, I'll pay the OSFC dues with interest also. I'll also pay Mr. Acharya 60 lakhs with interest. But I'm only making one submission, that is the OSFC should, if at all the OTS scheme is applicable, they should consider. I'll pay the amount. But I'm not disputing how much amount they will quote me. I'm only saying that if it is in vogue, let them apply and tell me the amount I'll pay.
With the lordship's permission,
where's
couple of facts for your lordship.
I'll pay your lordship.
Actually, the auction purchase of the NDC that is in question, the no due certificate that was stayed, was issued by OSFC much before the learned district judge passed the orders. And the no due certificate was actually issued because the auction purchaser himself had defaulted on the loan.
No, the district judge passed the order sometime in 2008, sir.
In 2012, your lordships.
No. The district judge's order is what date?
That was the miscase that was initially disposed of. Then the final order was in 17/8/2012, and the NDC was issued on 31/1/2012.
But there's already an order declaring the sale deed to be that auction to be bad, which we just saw read out.
Yes.
2008. That's an order of 2008, sir.
That is at page 46, your lordship. The operating portion. Page 45, I'm sorry, 45, paragraph 10.
What is the date of that?
The order date is, my lord, 19th of April 2008, page 46.
That's what? That's 19th April 2008, 4 years before your order. And the FAO order is?
FAO order is, my lord, 23/7/2015.
And sales certificate is after that. And meanwhile, there was a stay of the
no due certificate.
No, but what is you found out instructions? What is the exact amount due?
The lordship, the amount that was due was in 2001.
What is the amount due, sir? What was the amount due?
4 crores 33 lakhs, your lordship. That is a part of the counter also, your lordship.
Today, if he pay you for 433, you'll be happy. You don't want interest?
Lordship, that we need further instructions because from 2000,
that is what we passed it over, sir. Why can't you take instructions on the exact amount due?
From 2001 to 2022, compound interest on 4 crores 33 lakhs, your lordship, has to be calculated. So I need to file an affidavit.
You want us to do it or you will do it?
We've asked them, the corporation needs at least a day's time to calculate and come up to a figure before your lordships.
And who's appearing for this auction purchaser?
My lords, I am appearing on behalf of my senior Mr. Kanungo. My lords.
What are your instructions?
My lords, I am unable to obtain any instructions on today. My lords, may kindly allow me a short adjournment. I'll obtain instructions from the client.
Mr. Samir Mishra, learned counsel appearing with the petitioner on instruction states that (1) the petitioner is prepared to pay the entire amount paid by the auction purchaser together with simple interest at 6% per annum from the date of the payment of the amount by the auction purchaser till the refund of the amount to the auction purchaser. 2, pay the entire dues of the OSFC together with the interest due up to date. Paragraph. Mr. Mishra further states that he's prepared to pay the above amounts within.
My lord, I have taken instruction. If the amount is heavy, your lordship may grant me only 2 months' time.
No.
Whatever your lordship pleases, your lordship may fix, my lord.
No. You within 4 weeks. Full stop. Since the amount due in the above terms to the auction purchaser is known, the petitioner will keep a demand draft for that amount ready on the next date of hearing. As far as the OSFC is concerned, it will communicate to the petitioner the amount due to it within a period of 1 week from today. You communicate it to it. And the demand draft for that amount will also be kept ready in favoring OSFC by the petitioner on the next date.
My lords, may I place something
before? The above order is without prejudice to the rights and contentions of the petitioner of the parties and only to test the bona fides of the petitioner.
My lords,
I was only praying one thing.
For your lordships.
Yes.
My lords, since we are in possession of the said challenged property, and my lords, we have developed and set up our entire unit on that property, my lords.
You just now said you had no instructions. Now suddenly all of this is coming forth. How come?
My lords,
you just 3 minutes ago you said you had no instructions, correct?
My lords.
You're waiting for us to dictate the order and now come up with all this.
No, I'm really sorry, my lords. Instructions as on.
You better be, sir. When we asked you, you actually told us, if I'm not mistaken, that you had no instructions.
My lords.
Is it being fair to the court?
I'm deeply regretful, my lords. My lords,
What else do you know?
My lords, I'll obtain instructions from my client if we are able to match their bid, what they're willing to pay for the property.
Where is this property? Where is the property?
In the district of Balasore.
What has happened? The crop.
And what is the extent of this?
This is around 100 acres. They have sold it for 60 lakhs, your lordship.
So he's prepared to match it.
That is the region.
Actually, this is not a current date valuation. It was sold back
Even
in
on
2001.
that day also, it was 2.5
The possession
crores.
was handed over in 2002. It's 20 years since the OP number 3 has a possession of those assets, your lordship.
All right, without prejudice to the rights and contentions of the parties. It will be open to the parties to file their respective affidavits before the next date.
Much obliged.
List on.
I'm grateful.
Deeply obliged, man.
I beg your pardon, passover item number 13.
Sorry.
List on 13 September. Or 14 September. Sorry, 14 September.
Obliged, man. Deeply obliged.
So, my lord, I am beg to pardon. So, the item number, passover item 13. I am for the opposite party.
What is the order?
Item, the passover item 13.
So you can't come in whenever you like, sir. What is this?
My lord, beg your pardon, my lord. It was passed over.
You're Mr. Baral.
My lord.
Where were you? We've been hunting for you.
My lord.
Then you say Mr. Baral appears subsequently and has been informed of what is the date?
29th August. 29th August.
29th August. My lord.
Not yet come, is it? We ask an explanation why the and why not? Why is it not uploaded right away? No. We called it a 2. We said it now. This first question is already answered against. All right.
Supplemental list is admission item number 1.
Somebody was mentioning some 89.
May please, ma'am.
1 minute. Somebody was mentioning item 89.
Any mention from weekly list?
You were talking about item 89 or something.
No.
Some lawyer came and asked about 89, item number 89.
Yes, somebody was even.
89 to 9.
He asked me to wait for the password to be over.
89 to count.
All right. Weekly.
Supplemental list.
Supplementary. Sorry.
Supplemental list, fresh admission item number 1.
May please, my lord. My lord, annexure 4 is the rejection order, my lord. The prayer of the petitioner for promotion with retrospective effect has been rejected by the opposite party number 2, my lord. My lord, first, he was initially appointed as, my lord, junior clerk. And my lord, he has also passed the departmental examination in the year 2010. My lord, then a departmental proceeding was initiated against the petitioner. And because of the pendency of the departmental proceeding, the result of his promotion was kept in a sealed cover. And in the meantime, my lord, under annexure 1, his juniors have got promotion, the opposite party number 4 and 5.
My lord, on 4/7/2016, the departmental proceeding was finalized, where my lord, the punishment was awarded for stoppage of one increment without cumulative effect and treating the period of unauthorized absence in duty from 17/12/2013 to 5/1/2014 as leave without pay. And my lord, challenging the order of punishment, the petitioner has preferred an appeal, and the appellate committee under Annexure 2 has modified the order of punishment by substituting the punishment by awarding punishment of censured for mistake committed by him and period of unauthorized absence from 17/12/2013 to 5/1/2014. And my lord, the petitioner has approached this honorable court under Annexure 3 to consider his case for promotion with retrospective effect. That is from the date when his juniors have got promotion under Annexure 1. And my lord, the rejection order is under Annexure 4, where my lord, the opposite part number 2 has rejected the prayer of the petitioner for promotion with retrospective effect. And my lord, challenging the order under Annexure 4, the petitioner has preferred an appeal under Annexure 5. My lord, the appeal is still pending, my lord.
Then you wait for the appeal to be disposed of.
Yes, my lord.
Since the petitioner's appeal dated 28 August 2019 is stated to still be pending, a direction is issued for disposal of the said appeal in accordance with law within a period of 8 weeks from today, and the order to be communicated to the petitioner within 10 days thereafter. Full stop. The petitioner is still aggrieved by such order, to be open to him to seek appropriate remedies in accordance with law. The petition is disposed of.
May I pardon my lord, item number 89. Sorry, may I pardon?
Weekly list.
Right. My lord, the opposite party number.
Yes, please.
May I please, my lord? Lord, the opposite party number 1 to 3 have not taken appropriate step against the opposite party number 4 to 6.
Not unauthorized encroachment.
All right. Say the petitioner's representation.
Annexure
4 will be considered by the
collector
Jagat Singhpur. And after issuing notice to the petitioners as well as opposite parties, 4 to 6, and after giving them a hearing, and a reason order should be passed not later than 10th October 2022. Order should be communicated to the parties not later than 17th October. The court clarifies it has not expressed any merits.
Supplementary list, item number 2.
Okay.
My lord, on 29th March, I could not read the list properly. That's why it could not appear. My lord, kindly recall the order and restore it to the file, my lord.
I don't understand what is going to say. What's the main matter about, sir? You tell us.
My lord, that is the PIL, my lord. I am challenging the order that this monument hill has been going to be destroyed by the scheme.
You made representations, sir. Let them consider those representations. You say for the reason stated, the order dated.
My lord, kindly restore it. Then
29th March 2022 is recalled. Writ petition so and so is restored to file. In the main writ petition, you say the petitioner's representations, Annexure 5 series, shall be considered by the Secretary, Steel and Mines. Department.
72, the Law Tribunal put
and after hearing the petitioner on a date to be intimated to him at least 7 days in advance, and after getting inputs from the other parties, including opposite parties 3 and 5, 3, 4, and 5. The reasoned order shall be passed thereon not later than 1st November 2022. The order be made available to the petitioner not later than 9th November 2022.
Give one
The
month
court
time.
clarifies that it has not expressed any view on the matter.
My lord, beg your pardon, my lord, give the 1 month time, my lord, it is too late, my lord.
So they'll have to talk to the ASI, to the OMC, everybody is to be consulted, sir. It will take some time.
That is why I am lordship said that it should be hard on the merit, my lord.
Sir, either way, it is the same problem. The exchange of pleadings, everything takes months on end. This is far better. At least you get to know some decision of this. Then you can always challenge it if you're not happy with it.
Kindly give me a status quo order at least for till that date.
No, sir. We don't do that.
Supplemental list for orders item number 3.
Item number 3 is a disposed of matter by the order dated 11/5/2022. My lord directed to file a compliance affidavit. Though I have received the instructions regarding compliance of the order, but I could not file the affidavit.
When are you filing the affidavit?
I have not filed, your lordship. Grant me 10 days time. In the meantime, I'll file.
Mr. Mughali states that as per his instructions, the payment has already been made.
Yes. If your lordship grant me liberty, I can place those orders. Your lordship may kindly turn to page 4. And this is the compliance report submitted to the government advocate in the tribunal at page 5 from paragraph 3 to 5. My lord may kindly see. Page 5. Paragraph 3, that it is humbly submitted that the Honorable High Court in their order dated 1/7/2014 dismissed the writ petition and directed to release the arrear pension within a period of 1 month along with interest at the rate 9% per annum for the period from 2011-98 to 26/11/2009 and thereafter at the rate of 18% per annum till the date of actual payment. That it is humbly submitted that Government and Revenue and Disaster Management Department by their letter number sponsor dated 10/10/2014 sanctioned revised pensionary benefits of late Pitambara Satpathy, taking into account the job contract service rendered by late Pitambara Satpathy from 7/1/50 to 2/3/1970.
Copy of the affidavit dated 25th November 2016, submitted before the OAT in OA number 338 of 2004 has been handed over to be kept on
that
file.
was not filed in the OAT, that was supplied to the government advocate in the OAT.
Or supplied to the government advocate in the OAT. To be filed in OA number 338 of 2004 has been handed over. In that view of the matter, no further directions are called for the. This petition need not be listed hereafter. Right.
Supplemental list item number 4.
Item 4, Mali, in this case, I am for the respondent, my lord. Earlier, lordship directed to present with a draft of 78,000. The present respondent is bedridden, my lord. Unable to come, my lord. I press hot date, your lordship. I am ready. He is also with
to
me.
Prepare a demand draft doesn't require
12,000 is draft with me, my lord. That,
sorry?
That to earlier occasion, 12,000 draft is with me. That is expired, my lord. He bedridden. I press some days, 10 days time. I will do.
Where is the draft? You first hand over.
Here, my lord.
A draft of 12,000 rupees has been handed over.
In the month of January, I have
expired in the meantime.
What is this?
In the
How
month,
can it be?
yes, that
don't,
is
don't play the fool, sir. This is
now
taking
he's
the court for the, this is taking the court for a right.
No, my lord, he is
we take a very serious view of this matter. You've taken the court for a granted then. To get this extended.
I admit that.
You admit that?
No, my lord, I am sorry.
You admit that?
No, my lord, sorry.
We'll just record your statement that you admit it.
Present petitioner bedridden, my lord. You actually press 7 days.
Where is the certificate that he's bedridden? Where is the medical certificate?
Tomorrow I that bedridden. Who?
Sir, let us. You're before a high court. Please take these proceedings seriously.
Yes.
Where is the medical certificate to show your client is bedridden?
Tomorrow I'll publish.
There's no tomorrow, sir. You bring a medical certificate at 2 o'clock, or we'll issue a warrant for his production.
I paid 2 more, my lord. I already contacted today, my lord. I also
Where is your client?
Bedridden, my lord. Unable.
Where is he? Where is he, sir? He's
At Barampur, my lord.
Where is the medical certificate to show he's unwell?
I paid tomorrow. I'll produce that.
So tomorrow you get a renewed.
At 10:30, I'll produce that.
What are your instructions? Where is he?
He's at Bhubaneswar.
He's at Bhubaneswar.
No,
Barampur, sorry.
Client
Sorry, Barampur.
So both cities begin with B.
No, Barampur.
I have deposited also permanent element 1 lakh. Now quote 3,000 per month.
Sir, please tell your clients,
Yes,
don't
sir.
take this so lightly. This
Yes,
is a high court. It doesn't take us much to make sure that he's present here.
Yes, my lord.
What is he bedridden with? You tell us that.
He said that some cardiac problem. That's why he bedridden, my lord. I contacted
Counsel for the respondent claims that his client is bedridden, but is unable to produce a medical certificate in support of such claim and seeks some time for that purpose. He has not complied with the specific direction of this court that he should remain present with the demand draft for rupees 78,000. He prays for some more time for that purpose. Counsel for the respondent has in his hand a demand draft for rupees 12,000.
12,000. It was expired.
Which is expired. He undertakes to have it renewed and produce it on the next date along with the medical certificate of the respondent. List on 19 July.
Supplementary list item number 5.
May I please, your lords. In this case, my lord, the petitioner has approached the Honorable Court against the notice under section 148 as well as a consequential order of the assessment matter. 148 notice has been issued in 3 occasions. Annexure 1, 2, and 3 concurrently, my lord. Annexure 2, that is 31st March 2021. Then Annexure 3, again notice 31st 2021. Again notice Annexure 4, page 15 on 142021, man. He has acted on the notice on 14/2001, man.
So the other 2 are deemed to be withdrawn, sir.
They have not mentioned anything.
So if it is 1/4/2021 is covered by yesterday's order.
Your lordship, see. They have dealt in the assessment order at page.
No, but they already passed an assessment order.
Assessment order passed and it is within 31st March. And your lordship, see, the timing of delivery is 9:47 p.m. So it is within 31st March 2021. How can you say that it's beyond the 1/4/21?
My lord, they have issued 3 notice. First notice on 31st March. Second notice 30 March.
No, but you pass the assessment order on the basis of the 1st March, 1st April order.
No,
1st April notice.
Page 24.
Orders, date of order is 3/3/2022.
Page 24 of our class paragraph.
Sir, anyway, since now there is an assessment order and that is based on the 1/4/21 notice, you can challenge it.
My lord, I have respectfully submitted, my lord, that allegation is that there is a information from the investigation in Calcutta, basing on which the case has been reopened, my lord. Here is a difference of 56 rupees. 23 lakhs I have taken loan from that party.
Whatever, we are not on merits.
My lord, we are not, so that we are not in merits, my lord. I only technical point. As per Omega Steel case, that assessment order has to go. Because they have acted on 1/4/2021 notice. They have mentioned in the order itself. In notice dated 1, that is page 24, last line, my lord. In notice on 148, we had in notice number dated 1/4/2001 for the 16/17 has been issued and served on you in connection with your assessment proceeding going on.
Sir, if it is on 1/4/2021, they've acted on the 1/4/2021 notice.
My lord.
Then clearly, after the Supreme Court judgment in Ashish Kumar, it will be deemed to be under the new amended provision, correct?
Separate notice they have issued on 48 days.
But your assessment order begins very funnily. Just see this. notice under 148 dated 31st March was issued.
That is mentioned in first line, first page of the assessment area. In the page number 24, my lord, same assessing official dealt with the notice under undated 14201, my lord. The passing order based on the notice 1042021. So ambiguous case is square left.
No, 1 minute. Where do you get that? After that, the second line, he says, this is a notice dated 31st March. Correct?
My lord.
Thereafter?
Thereafter, it page 24, my lord. And last line, a notice on 148, having notice number, such and such dated 142021 or 1617 has been issued and served on you in connection with your assessment proceedings. So assessment proceeding will be initiated based on notice 142021. Had it been so, then it will go on as per Tommy Gatton case, my lord. Or at best, Ashish Agarwal case.
2.23 and above, Lord. The assessee has not complied the notice issued or mentioned above. Hence, the another notice on 42.1 dated was issued to the assessee and assessee was required to comply the notice issued earlier.
No. See, this assessing officer seems to have no.
The 3 notices have been issued to the petitioner.
No, he doesn't seem to understand the legal implication. Notice issued on 31st March is not the same as notice issued on 1st April.
Because it has not been complied with, as it appears not. Because he's not been complied with. Therefore, the subsequent notice has been issued.
No, but it can't simply be like, because there's an intervening date, correct?
Yes.
The law has changed with effect from 1/4/2021.
But the proceeding is
He's not acknowledging that the law has changed.
Absolutely correct, Lord. But the proceeding has been initiated prior to 31st March 2021. Therefore, my humble summary, it should be in prior.
No. What is it pertaining to which assessment year?
It's not 16-17. That is within 4 years. Now, first notice is within the year, which has been 4 years. That is been complied with. Now. That is not the issue here. He is stating that it is issued after 1/4/21. He has been received. Therefore, he says that it should be covered with the ambiguity. But my summary is within 4 years. There is no deficiency in the issuance of notice.
Let the record has to be called for. Let the appellate authority examine it, sir. Let the appellate authority examine all that.
Only my privilege, that if you go to the appellate authority for 56 rupees, I have to pay 20% of the disputed demand.
How many rupees?
56. Only 23 lakhs is I have taken loan, but the investigation says that 23 lakhs 56 rupees. I am taking loan. Only different 56 rupees.
So what is your what is the grievance? So 56 rupees means how much is the tax demand?
They have already made a demand of 23 lakhs 56.
No.
They are raising a demand on the amount of 23 lakhs 56 rupees. I am taking loan 23 lakhs. That is 56 rupees of only deviation. So your lordship said in Delhi High Court, my lord, are giving blessing, my lord. Suppose it is investigation showing sadar. So it has to be duly complied here with.
That is against the notice. Now you are in the assessment order.
No,
your lordship has passed the order basing on the notice issued on 12/8.
Notice is itself illegal. Honest. Then how can you say that?
Where do you say that it's been served on 31st March itself? You say some 9:50 p.m.
Lord, running page 14, Annexure 3 last. Wednesday, 31st March 21, 9:47 p.m.
Where did you get it?
Running page 14, Annexure 3. Last. Location Bhubaneswar, India. Before that, 31st March, 9:47 p.m.
No. This here, the photocopy that we have, 9:47 p.m.
Yes.
That are not necessary for 1/4/2021.
No, it was not served on him.
No, it is not served in the sense that it's mail. It is communicated through electronically.
No, this is signed at that time, sir.
No,
this is signer and the date and time of signing.
Yes.
Not served.
But as per the procedure, Lord, the date of signing, it should be electronically signed.
Sorry?
In the date of signing, the notice has been issued electronically to the petitioner, Lord.
No, where do you get that?
But I have to take it on that issue.
You're making an assertion as if it's taken for granted.
It is clearly mentioned. Your lordship had taken the issue on this issue that it was issued, they signed on after 1/4. After 12:30, thereafter signed. Therefore, your lordship say it is received.
No.
That issue
that was obvious. If it is signed beyond, then obviously it's also served beyond. Here we don't know if it was served.
But ultimately, not assessment order has been passed. Your lordship concerned.
No, but why should he pay that 20% on that 23 lakhs and all that?
20% not filing, Lord. This is for stay.
That's
Filing,
right.
there is no
So
statutory
you make a statement that you will not take any coercive action, then we'll record it.
No,
You can't have it both ways.
No, I cannot.
You make that statement, we'll immediately say that you make that statement.
I cannot.
So you say, Council for the Revenue says that refers to copy of the notice dated 31st March 2021, which is at Annexure 3, and states that it has been electronically signed on 31st March 2021 at 9:47 p.m. However, he is unable to inform the court at this stage whether the said notice was in fact served by 12 midnight on the SSC on that date. It must be mentioned here that according to the SSC, he did not receive a copy of such notice prior to midnight on 31st March. You did not receive this. That's what you're saying.
My lord. Now, 1 for Project 21, my lord. They have signed at.
No. This notice, did you get or not? We'll forget. We'll come to that 1 for.
I have not got notice, my lord.
Before that, there is a notice. Before that, your lordship. Page 13 also a notice, 140.
How many notice you have issued?
Before that, also a notice, my lord. I'm sorry, my lord. Annexure 2, 13, page 13.
No signature, my lord.
No, electronically issued.
No, even electronically not signed.
Yes, sir, that is not signed. But 3 notices have been issued, my lord.
No, you can issue any number, sir. The question is that have you served him, even one of them? All right.
Well, I'll produce that.
An affidavit be filed by the opposite party specific to the above issue before the next date. Interim order to continue. List on 21st September.
Supplementary list item number 6.
My lord, item number 6, permitted to withdraw with liberty to file a better application.
Counsel to the petitioner seeks leave to withdraw this petition with liberty to file a better petition. The memo is taken and record. This post office withdrawn with liberty is paid for.
Appearance will be noted.
Supplementary list item number 7.
My lord, item number 7, permitted to withdraw and file a better application, my lord.
Same order in this.
Supplementary list item number 8. Supplementary item number 8.
Pass over.
Supplementary list item number 9.
Your Lordship, in item number 9, I am appearing on behalf of the petitioner. Your Lordship, in item number 9, the petitioner has challenged if Your Lordship may come to Annexure 1, here the petitioner along with 3 other people has challenged the order dated 21/2022.
Where this matter is covered by the order dated 26/4/2022 passed in WPC number 36493/2021. In fact,
I have
this Annexure 1, and in subject there are 3 petitioners, 3 persons are there: Sushanta Sahu, Devdutt Jani, Rabindra Mishra, and Prasad. In respect of Sushanta Kumar Sahu, this order has been passed. Here, there will be little change in the first paragraph.
The same order can be passed for the other 3.
Same order, but in all those cases, we have filed the counter. But this first paragraph has to be little modified.
All right. You see, in view of the order passed by this court on 26th April 2022 in writ petition civil 36493 of 2021, filed by Sri Shishanta Kumar Sahu, who is at serial number 1 of the letter dated 3rd February 2022.
No, that is 21/2022.
21/2022.
Annexure 1.
Right. Okay. So
in fact, out of 5 persons,
who's the first mentioned? No, who's the second mentioned person in the letter dated 21/2022 of the Government of Orissa Home Department? The same benefit as extended to him by the said order is extended to the present petitioners.
The last
whose
portion
names
has
also
filed
figure
a-
in the same letter.
Last person, Prashant Kumar Mali, he has also approached this honorable court in WPC 27190.
The second person has also approached. If the lordship may see that the order dated
It's all right, so we don't have to mention all the orders. All right.
Supplementary item number 10. May I please your lordship? I am for the petitioner. I have challenged the public notice issued by opposite party number 3 for opening up one IFL on shop at Durga Bazar, Daspala, in violation of Rule 26 of the Orissa Excise Rules and for violation of Rule 31 and 32 for non-service of public notice, which is mandated. And
My lord, he has lodged an objection before the collector under Annexure 5. If it is within the time period, that will be taken care of by the collector.
my lord, they have not taken into account or they have not considered my objection at Annexure 4 and 5, and they have already issued the license in the meantime in violation of Rule 26, 31, 32, and 51 clause 6 of the Odisha Excise.
When was the license issued, sir?
In the last week, my lord.
Last week?
Yes, my lord.
Then it has become infructuous. He has to file a separate. Your lordship may kindly have a glance at Annexure 3.
The license is issued in favor of opposite party number 5.
My lord, opposite number 5 has been made a party.
No, the license is issued in her favor.
Yes.
My lord.
The lordship may kindly have a glance. Annexure 3. The last date of objection is 18th April 2022.
Yeah.
Annexure 5. The objection was raised by them thereafter on.
No, there's one more at Annexure 4.
Yes.
Annexure 4 is 18th April.
4th April.
No. Actually, it has been received only on 22nd June. 25th April.
Yes, superintendent.
No, I think it was after the last date, sir. The objection was delayed.
After the last date.
Objection was given on 25th April. Just see the stamp on the top of Annexure 4. Your objection was delayed, sir.
After the expiry.
My lord, mechanic have a glance on Annexure 6 series. It is a report of the inspector who has already given a report that the notice was not properly served as it was not served on the chairperson of the urban local body, the NAC chairman. So it was non-service, it was insufficient service, my lord.
No, but obviously you are aware of it because you gave an objection letter on 18th April but did not deliver it till 25th April.
My lord, I have
you drew up your objection on 18th April, correct?
My lord.
Why didn't you not give it on the same day?
My lord, on 18th April, in the last moment when I came to know the notice, I have sent it through email, and then I have given the written in the hard copy.
No. Come on, sir. This you could have easily gone and given it yourself.
That is not.
Naigad is not so far. You are in Daspala. You are a chairperson of NAC Daspala, and Naigad is next door.
My lord, kindly have a glance on Annexure 6 at page 37. It is a report of the inspector, my lord.
Sir, we can go through all those reports. We are asking you a simple question. The last date is 18th April. Correct?
My lord.
You drew up this objection on 18th April. That's what you say. You have signed it on 18th April.
My lord, on 8th April, I have sent it on email to the collector in the last moment when I came to know the notice was not served on me properly.
No, sir. 18th April, when you drew up this objection, you could have delivered it on the same day in person in Naigad. You're not sitting in some remote area from Naigad. You're sitting in Daspala.
My lord.
From Daspala to Naigad, how much will it take, sir? You tell me. I'm new to Orissa. You can tell me.
It will take maximum 1.5 hours.
I have a vague memory. I've done that route. That's why I have a vague memory. How long does it take from Daspala to Nayagarh by road?
My lord, by maximum 1.5 hours.
So?
My lord, I
You
have
missed the
sent it to
deadline,
you.
sir. You missed the deadline and now you want the court to interfere. This is the whole problem.
My lord, kindly have a glance on Annexure 6 aspect 37. May I read it? It was found that the format public notice has not been duly served.
No, all that is pointless, sir, because you are aware on 18th itself and you are writing an objection.
My lord, on 18th, I became aware, and on 18th, I gave an objection by email, my lord.
No. You could have gone and given it, sir. You gave it only on 25th. The stamp on that document shows 25th.
My lord.
You say the petitioners appear to have missed the bus as far as objecting to the proposed license granted to opposite party number 5 of the IMFL off-shop.
On-shop, my lord.
On-shop at Daspala. Full stop. Counsel to the petitioner has drawn attention to an objection letter dated 18th April 2022 of the chairperson of the notified area council NSC Daspala. Full stop. From the photocopy at Annexure 4, it appears that it was in fact delivered in the office of the superintendent of excise at Nayagarh only on 25th April 2022. Paragraph. Counsel for the petitioner then refers to a report dated 21st April 2022 of the Inspector of Excise Nayagarh stating that there was that public notice in Form 8 had not been duly served. Open quotation, as the NAC chairman is quite ignorant about such public notice, unquote. The fact of the matter is that the NAC chairman was aware of the notice definitely on or before 18th April 2022, and he therefore wrote out his objection on 18th April 2022. Full stop. The last date for submission of the objection was 18th April 2022. Full stop. Daspala is just 1.5 hours by road from Nayagarh. It should not have been difficult, therefore, for him to have arranged to have the objection delivered in person at the office of the Superintendent of Excise Nayagarh on the same day. No explanation is forthcoming why this was not done. Paragraph. With the petitioners having missed the bus in objecting as provided under the statute in question, the court is not persuaded to interfere in the matter. The writ petition is dismissed.
Obliged, man.
After lunch, sir. Did you see the order now?
Past order 46.
Written explanation. Today will upload. We'll make sure it's uploaded today. But thank you for bringing our notice to that.
Obliged, Your Lordship.
So the first question, like you say, is answered against you.
Yes, Your Lordship. The first question, Your Lordship, is answered in favor of me. Our petition for engaging an advocate was rejected. So we have said since the 36(4) is ultra virus, we could be allowed.
No. Thus, the plea by the petitioner that the impugned order is legally vulnerable on account of violation of 36(4) has no legs to stand.
I'm sorry, Your Lordship. I just got a little confused.
Yeah. So the first question anyway doesn't survive.
Yes, Your Lordship.
Now the second question.
Lordship, coming to the second order, I have given certain judgments.
46.
The order is at Annexure 7, page 28.
Yes.
May I proceed, Your Lordship?
Yes, please.
Your Lordship, I would like to take you to page number 23 for a moment. That is Annexure 5. That is our written statement.
Right.
In our written statement on para 18, we had already given a clause that in the event the inquiry proceeding were found to be improper and unjustified and were not in accordance with evidence available on record, the management may be given an opportunity to adduce evidence to justify the action taken by it. Now, Your Lordship, we had given a petition regarding that on 8/1/2013. That petition has been rejected. To that, I have given certain judgments.
So you must be permitted to lead evidence to justify the.
Your Lordship, the issue of whether the fairness has been taken care of in the domestic inquiry should be decided as a preliminary issue or not.
Correct.
That we had requested in our petition, stating that that may be decided as the preliminary inquiry along with the other issues can be decided later on. That petition was rejected.
So that's contrary to the law laid down actually.
Yes, Your Lordship. The law, it is a settled law in AR 2001 Supreme Court.
Correct.
That I have.
Lakshmi Deva. Correct. Who's for the workman?
I'm for the workman.
So how do you justify this? There has to be a separate preliminary issue. It has to be decided as a preliminary issue for which evidence has to be led. Whether domestic inquiry is fair, that's settled law.
When at this honorable court, in case of Shankar Prasad versus Tata Iron and Steel Company, 2010, 1 Wheeler, page 927, it is decided that the tribunal should decide all issues in the dispute at the same time.
But that's not in consonance with Karnataka State Road Transport Corporation. Show us the judgment. Let's see if they've discussed this.
My lord, 2010 judgment, I have no copy, my lord.
But Your Lordship, to
relying on something, you'll have to have a copy.
Page 927.
So if you're relying on something, you should have a copy. You should give copies to us.
Judgment at present not with me. Only the reference, my lord.
Your Lordship,
anyway, the judgment of the Supreme Court is very clear.
I beg apologies. My senior has given a judgment of 2010. In 2013, Honorable Retired Justice Sanju Panda had also given a judgment regarding that, which I have referred to, regarding the issue that
That's it. That's a single judge.
Yes.
Yeah, that's as a single judge. No, but she's referred to 2001.
She has referred to the AIR
Correct.
judgment.
That holds the field. That holds. You see, the present petition by the management seeks the quashing of an order dated. Seeks the quashing of two orders. One, an order dated 11th December 2012. Passed by the Labour Court, Sambalpur. In ID case number 14 of 2011, declining the prayer of the petitioner to engage a lawyer to conduct its case. And two, an order dated 5th February 2013, passed by the Labour Court. In ID case number 14 of 2011, rejecting the application filed by the petitioner that the fairness issue regarding fairness of the domestic inquiry should be decided as a preliminary issue, permitting the management to lead evidence in that regard. Paragraph. As far as the first question is concerned, Learned Counsel for the petitioner states that by virtue of a judgment dated 13th May 2022, passed by this court in Representation Civil 2007 of 2013, the issue has been decided against the management. Will stop, this court has perused the said judgment by calling for the file of the said writ petition and finds that indeed the prayer of the management in that case on similar terms has been rejected. Paragraph. As far as the second issue is concerned, the decision of the Labour Court is contrary to the decision of the Constitution Bench of the Supreme Court in Karnataka State Road Transport Corporation versus Srimati Lakshmi Devamma, AR 2001 SC 2090. Can you tell us the para number?
Your Lordship, in the entire judgment, there are various judgments where they have placed it.
No, there must be a summation.
Your Lordship.
Where in para 39, it has been held as under. Reproduce the whole of para 39 paragraph. With the law being absolutely clear in this regard, the court sets aside the order dated 5th February 2013, passed by the Labour Court Sambalpur, and holds that the prayer of the management to be permitted to lead evidence on the preliminary issue of the fairness of the domestic inquiry shall stand allowed, and further that issue will be decided first by the Labour Court as a preliminary issue. Paragraph. The interim order passed by this court is accordingly vacated. ID case number 14 of 2011 will now be listed before the Labour Court on 29th August 2022. The Labour Court will now proceed in accordance with law by taking up the preliminary issue and permitting the management to lead management and the workmen to lead their respective evidence on that issue. And after deciding that issue, proceed in accordance with law.
Obliged, Your Lordship.
The petition is disposed of in the courts. There's no LCR, nothing.
Supplementary list, item number 11.
May I please, Your Lordship?
Yes.
Lordship, this is a public interest litigation, my lord. The petitioners are the inhabitants of Sambalpur district, my lord. There is a year-old temple of Ma Samalai in the district of Sambalpur district, my lord. State government has initiated a program, that is Samalai, to develop the temple area, to develop the central area. And in order to implement the Samalai plan, the state government has to occupy certain land around the temple area, my lord. So there are some private lands and some government lands.
Let me submit what has happened, my lords. There are two writ petitions. First writ petition is 16945 of 2022. In this writ petitions, prayer has been made to implement the Samalai plan, which is formulated by the government as early as possible, so that the unauthorized occupiers can be evacuated. And so far as the second one is concerned, this writ petition has been filed by some of the unauthorized occupiers. They claim that this policy, which R&R policy, your lordship knows, in Cuttack, when the SCB Medical College expansion, and we have formulated a policy, and that policy was challenged before your lordship in many writ petitions. And the same policy we have also adopted in so far as this particular plan is concerned, this development of Samale Mandir. And they have challenged that this policy is not legal and it is liable to be quashed. And accordingly, the second writ petition is filed, in which we have also filed counter affidavit. And since there is a stay order in the second writ petition, we are unable to progress with the developmental work. The work is stopped. The petitioner in the second writ petition, perhaps, yes, he is there.
I am appearing, your lordships. I am the counsel in the second writ petition, your lordship. My case is quite different, your lordships. My case is the petition. In my case, your lordship, the petitioners are claiming just compensation under the right to fair compensation transferring land acquisitions of 2013, your lordship.
It is a government land.
The act is of 2013.
No, but if this is not your private land, correct?
It is a government land, admittedly.
That is the as per that rule, as per that act, your lordships, the petitions are coming under the affected families. Under the act, it has been prescribed.
No. If the affected family is not on government land, sir, the affected family is on private land.
Yes.
Please, you're reading the act wrongly. The act is for acquisition of private land. It could happen that on private land, the others have some interest, like a cultivating interest, like living off the land. So off that private land, there could be others who have an interest in the land, which is being recognized in the 2013 Act, and it's being dealt with.
Lordships, kindly allow me to explain.
It is not to do with government land.
Lordships.
You're completely mistaken to say when government land is being used, you can still get compensation.
Lordships, kindly allow me to explain, your lordship, that the matter has been heard at length. This is an assignment of court number 1, your lordships. After hearing that matter, your lordship, the notice has been issued and the opposite party was directed to file the counter, and that matter has been posted to 14th, your lordships. That matter has already been heard at length, and I have convinced this honorable court that...
You're already convinced?
Yes.
No, my lord, may I tell you, lordship?
What is this?
Lord,
what kind of argument is this? Once notice is issued, you already convinced the court.
Affected family. May I read that clause, your lordships?
Land acquisition. My lord, may I tell you, lordship? The nomenclature is land acquisition. The honorable court proceeds on the assumption that they are owners of private land. The government
that's the whole problem, sir.
Yes. In all fairness, my lord, they should have come with clean hands and said this is a PIL where our private lands are going. That's the problem. So therefore, the assignment is only in this court and no other court, even otherwise.
I have filed that case for the individual rights. The contractor has got no rights to file and
Sir, do you own that land? Let's be clear on that.
Yes.
Lordship, kindly allow me to place that act, section 3 of that act. Just
sure.
To place that.
Sure.
Affected families, your lordship. Affected families, section 3 of the act, your lordship. Section 3 of this act says affected family includes a family residing on any land, whether it being a private or government land.
No, you're now adding it yourself. You're looking at us and adding this line. Are you reading from the statute, whether private or public land?
No.
Please. When you're reading the statute, you read the statute.
Beg pardon. A family residing on any land in the urban areas for preceding 3 years or more prior to the acquisition of the land.
Which land, sir? What is the definition? The land is also defined.
My lord, would your lordship start with section 2, my lord, if your lordship don't mind?
Correct.
The provisions of this act, my lords have it, my lord?
Yes.
The provisions of this act relating to land acquisition, compensation, rehabilitation, and resettlement shall apply when the appropriate government acquires land for its own use. So therefore,
there is no acquisition at all.
I can't acquire my own land.
First of all, there has to be a step to acquire.
Deeply obliged.
Then all of the others will apply.
Correct.
Here there is no acquisition notification at all. It's so misconceived. This whole thing is misconceived.
Absolutely.
Your Lordships, kindly see, there are other provisions also. Those who are residing.
Sir, if there is, first of all, the first step has to happen.
Lordship.
The government has to issue a notification for acquiring.
Lordship.
Where is that?
Showing our intent.
1 minute.
I'm sorry. I'm so sorry.
Sorry. You show us that. Where is that notification to acquire these lands?
Section 4, your Lordships.
Sir, kindly listen carefully.
Lordship.
Where, I'm not saying where is the provision.
Lordship.
Where is the notification issued in this case for acquiring these lands?
No, that is my claim, your Lordship.
What is your claim? It can't be a claim.
My humble submission is
Sir, we can't compel. 1 minute, just understand. You have to be very clear.
Lordship.
We can't compel the government to acquire its own land, correct? Have you ever heard of government acquiring its own land?
The government can acquire its own land, but the due
Sir, this is remarkable. What you are now submitting is just totally remarkable.
The due process has to be followed.
1 minute, sir.
Your Lordship, the
1
due
minute
process has to be followed, your Lordship.
1 minute. Can you answer the question?
Lordship.
Under this act, government will acquire its own land?
If somebody is residing.
Sir, please answer the question carefully.
The law is silent. That is
silent. Will you acquire your own land?
Your Lordships, all lands belongs to state of India.
No, not necessary, sir. What are you saying?
State of Orissa.
No, sir. You're mistaken on that. There are so many private lands. People will be aghast if they hear you now. There's no need for this law if all lands belong to the government.
Your Lordships, kindly allow.
Government, sir, the problem is you're not prepared to listen. You're not listening carefully to the question. Will this law be used to acquire government land?
Even if the government land is, if somebody is residing on the government land, and that has to be used for the government purpose, your Lordship, that the persons residing there.
You're not answering. That's why I'm saying, sir, you're not listening carefully. You're not listening carefully. Again, I'm repeating the question. Will this law be used for government to acquire government land? Yes or no?
In my humble contention, your Lordship, as per section 3, yes, your Lordship.
Sir, you have to go back. If you are right, we have to go back to the law college. If we are right, you have to go back to law college. One of these things have to happen.
My humble contention.
No. Because you have made a very significant answer you have given. You are saying government has to acquire its own land under section 3 of this act.
Because that has been, the enclosures have been
living there. Both of us, you should credit us with some knowledge of the law. We think you are wrong in the statement you have made.
Your Lordship, kindly have a glance to the scheme also.
First, let's talk of the law. They will come to the scheme. Without there being a notification to acquire land, the scheme does not come into force. There is no scheme. Scheme is only if there is a notification to acquire the land. If the land belongs to government, no notification will be issued under this law to acquire government land.
But they have provided in the scheme also that they kindly have a glance to the scheme.
Sir, this law, we are talking about this law or not?
Lordship, under that law, under that act, they have formulated a scheme and they have provided provisions for acquiring the land for the slums areas, which belongs to government.
For this project, where is the notification under this law? First shows the notification.
Notification is on. I have annexed in my read petition, your Lordship.
Let's see.
They have formulated the scheme, your Lordship.
Sir, please don't jump from one thing to other.
Lordship.
Under this law, where is the notification for acquiring the land?
Kindly have a glance to my read petition, your Lordship. Counter that.
You can't acquire government land.
This is another policy.
You also kindly pass over the matter. I have missed out my main read petition.
We'll give you the.
Okay. Okay, sir.
Listen to us carefully, sir. Please show us the notification issued under the 2013 Act acquiring the land in question. Have you understood the question?
Lordships, I understood.
Please show us, I'm just repeating, please show us the notification issued under the 2013 Act for acquiring the land in question.
Kindly have a glance to Annexure 7, your Lordships.
There's no Annexure 7.
Annexure 6, they have Government of Odisha, Revenue and Disaster Management.
So Annexure 7 is a notification under the 2013 Act?
That they have mentioned compensation itself be paid as per provisions.
So please, you're not listening carefully, sir. We've repeated the question twice. What have I asked you to show me?
Whether any notification has been published so as to acquire the lands for the public purpose. That is the question. No, they have only formulated the scheme under the Act.
Because it's a government land, sir. So there is no scheme under this Act. The scheme that they have formulated is for rehabilitating people found as encroachers on government land.
Lordship is right.
You're not making a distinction between what is a scheme for removal of encroachments and a scheme in terms of rehabilitation scheme in terms of the Act. You've lost the distinction, sir.
But the encroachment has to be removed through due process of law, your Lordship.
That is a different issue, sir. You started your argument under the 2013 Act. You started reading Section 3. You started telling us government can acquire its own land under this Act. All of it is totally misconceived.
Because
totally.
Kindly bear with me. There is provision under this Act that if somebody is residing.
You're completely mistaken, sir. This Act itself will not apply if the land is government land.
Government land, but if that has been acquired for more than 30 years, Lordship, the government has to settle.
Acquisition. You're not even using the correct words. Who has acquired it? Who has acquired it?
The government has acquired it.
Acquired it. If it is government land, how will it acquire it, sir?
Because by way of long possessions, they have got their
You're completely mistaken, sir. This government land doesn't perfect its site by long occupation.
Your Lordships, there are certain laws in the OPL Act also. It provides that if there is a long possession for 30 years, the lands has to be settled in favor of the encroachers. Even if he is an encroacher and he is in long possession in 30 years, then land has to be settled in the favor of the encroachers.
Have you made this argument in your petition?
Lordships,
are you claiming? Let's be clear.
Lordship.
Are you claiming that you have perfected title?
Lordship, I have claimed it. I have mentioned it.
What?
Kindly have a glance.
You have to file a suit for that anyways.
No,
cannot. You have to file a suit. You can't simply make a statement.
Suit is not maintainable. On 8 applicants, and if it is brought to the knowledge of the authority.
So you're completely mistaken. I'm sorry to say.
I have taken
you're mistaken. You're completely mistaken on the legal position. You're completely wrong on the legal position.
That provision has been mentioned in the Act also, your Lordship. If it has to be settled by the authority, that the land will be.
So you initiate proceedings under the OPL Act if you have to. You file a suit if you have to. This writ petition is misconceived. There is misconceived.
No suit is maintainable under the OPL Act, your Lordship. It has been prescribed that it has to be brought to the knowledge of that authority. Thereafter, the authority.
So your prayer. Let's come to your prayer in your petition. Your prayer is not that your title must be declared. Come to the prayer.
No,
your prayer is not that since I have lived in this land for 30 years, it becomes my land. That's not your prayer.
No, that is a different issue.
What is a different issue? What is a different issue?
By way of long.
You are now arguing that since you have stayed that land for 30 years, you have perfected title. Correct?
Lordship.
Where have you prayed for that? Where have you prayed for a declaration?
I have made an effort.
Please come to your prayer. Where is the declaration?
Declaration only I have challenged the scheme. That has to be.
Sir, so you're arguing anything you like. This is completely beyond the scope of your writ petition. Anything you want, you just argue.
No,
It's factually wrong, legally wrong. There's no prayer.
My prayer is based on my averments, your lordship. My whatever I have prayed in my writ petition, that is based on my averments, your lordship. I have taken in all the averments that I have quoted all those provisions of that law in my writ petition. By which provision of law I should be entitled to get the compensation under this act. That is my humble concern. Crores of rupees has been and if the poor litigants all belongs to scheduled caste, your lordship. If the poor litigants get their legitimate dues compensation as a just compensation, what is wrong in it, your lordship? That is my humble concern. I am not against the progress, your lordship. My humble concern is if the poor litigants all belongs to scheduled caste.
So please argue the law,
lordship.
Right? Please argue the law. You're completely wrong on whatever you've argued in the law so far.
Kindly allow me to.
You started saying government can acquire its own land under the Land Acquisition Act.
Kindly allow me to file a rejoinder, your lordship. Yesterday I have just.
There's no rejoinder, nothing, sir. There's no rejoinder.
Yesterday I have received the counter, your lordship. Kindly allow me just 2 days time to file the.
We've heard you, sir. We've heard you.
I'll 2 days time to file the rejoinder.
Sorry, sir. Sorry.
I have whatever I have submitted. All those things are in the law act itself, your lordship.
Just say this writ petition 13241 of 2022. The present writ petition prays for a direction to the opposite parties. No, prays for quashing of the open quotation rehabilitation resettlement scheme for Samlay plan, unquote. And for a direction to the opposite parties, open quotation, to formulate a new scheme for rehabilitation resettlement of the petitioners in accordance with the provisions of the Right to Fair Compensation and Transparency in Land Acquisition Rehabilitation Resettlement Act 2013, unquote. Bracket hereafter the 2013 Act, bracket. When this petition was heard on 27 June 2022, notice was issued and an interim order was passed with this court directing that, open quotation, no coercive action be taken against the petitioners till the next date, unquote. The petitioners, on their own showing, are
Page 13, my lord, para 13.
Stated to be residing on land which forms part of the Samleshwari Temple Area Management and Local Economic Initiative, bracket Samale, bracket plan. Full stop. The petitioner has stated to be residing on the land since long. Full stop. Initially, they filed a representation dated 3rd January 2022, facing the prospect of their having to face rehabilitation under the Samlay plan. Full stop. They filed writ petition civil 6710 of 2022 in this court. Which came to be disposed of. Where is that order? On 12th April 2022. Requiring the collector Sambalpur to take a decision on their representation. Full stop. What happened on that representation?
They did not consider the representations.
No, where is that?
Lord, that is page 62 of the counter affidavit, my Lord, annexure B.
Where's the counter?
After filing of my present writ petition, they have given that, Your Lordship.
It appears that on 7th May 2022,
If you Lordship, page 63, my Lord, the first paragraph, reply to para B.
yeah. A hearing took place on 7th May 2022, and a copy of the proceedings drawn up pursuant thereto has been annexed as Annexure B to the counter affidavit filed in the said writ petition. Full stop. It is inter alia mentioned that, open quotation, there is no instance of use of any force or coercive measure by any of officials connected with the scheme, unquote. Full stop. Hence, petitioners are requested to cooperate with the district administration for smooth implementation of the project, unquote. Paragraph. What is not in dispute as far as the present petition is concerned is that the land on which the petitioners are presently occupying is government land. So what is also not in dispute is that there is no notification for acquisition of any land issued by the government under the 2013 Act. And that is not surprising because there's no question of government acquiring its own land.
May I interrupt you?
Under the 2013 Act. Full stop.
May I interrupt you?
Unless there is an acquisition of land in terms of Section 2 of the 2013 Act, the question of the petitioners seeking any relief of rehabilitation resettlement in terms of the 2013 Act does not arise. Paragraph. Counsel for the petitioner sought to defer to Section 3 of the 2013 Act and the definition of single quotes affected family, unquote.
And landowner, Your Lordship.
And single quotes landowner. All these definitions under Section 3 of the 2013 Act would come into play only if there is a acquisition of land in terms of the 2013 Act. Full stop. In the considered view of the court, the 2013 Act does not come into play at all as far as the present case is concerned. Paragraph. As far as the scheme for rehabilitation is concerned, since it applies precisely to persons like the petitioners who are in occupation of government land and seeks to rehabilitate them without subjecting them to any coercive measures of eviction, the court finds no reason why the petitioners should resist such a scheme for rehabilitation. Full stop. Paragraph. The entire premise of the petition is based on the 2013 Act, and therefore the very legal premise on which it is based, and therefore the petition is misconceived on proceeding on a false premise that there is an acquisition of land in terms of the 2013 Act. The fact of the matter is there is no such acquisition notification. And there cannot be since the land in question is government land. Paragraph. For the aforementioned reasons, the court finds that the interim order passed in this court by this court on 27th June 2022 cannot continue any longer. Stop. The said interim order is vacated. IN number 8432 of 2022 is dismissed. In the main writ petition, you say, counsel, the petitioner seeks to file a rejoinder to the counter affidavit. Full stop. Rejoinder be filed before the next date. Just take this. It must be mentioned here that you say writ petition civil, you say since the companion writ petition is a public interest litigation seeking implementation of the Samlay plan, and that was listed before the court today, writ petition civil 13241 of 2022, which concerns the same issue, was directed to be listed with this petition. Full stop. So in 16945 2022, there's already, you see, Mr. D.K. Monti appears on advance notice and accepts notice for the opposite parties, 1 to 4. You'll have to take steps to implead all the petitioners in the other petition. No, he wants their removal.
The contractor is only having the commercial interest, your lordship.
Asking for removal of encroachments. So all the people affected are to implead all the petitioners in the companion writ petition.
Yes, lordship, I will implead.
Counsel of the petitioner states that he will take steps to implead the petitioners and writ petition civil 13241 of 2022 before the next date.
The lordship attack both the petitions.
List both these petitions on 19 September 2022.
Another writ petition of similar nature is also pending,
and
your lordship may tag it this WPC 26247 of 2021. Same prayer, same.
Is there an interim order in that?
No, that is
list along with
26247 of 2021.
26247 of 2021. All right. All right.
Supplemental list for admission, item number 12.
May I pray, your lordships, before, even if the petitioners are getting compensation under the scheme also, your lordships, so before getting the compensation, no coercive measures should be taken against the petitioners.
Who is taking, sir?
That is there. That is always there.
Forcefully, they have demolished the petitioners' once roof. The petitioners' once roof has already been demolished forcefully. So my humble prayer is, your lordships, before giving them the
you
compensation.
First participate, sir. You cooperate. Let's see what you do. Yes.
Item 12.
Yes.
That one.
Item 12.
My lord, item 12 on behalf of Mr. D.P. Manthi, I request this matter be taken up day after tomorrow.
All right. In 13241.
day after tomorrow.
No. What's the matter about, sir?
There's a OEM matter, my lord. Actually, Mr. DP Manth is dealing due to his personal emergency. Has traveled to Chennai, my lord. Yesterday only has traveled to Chennai. Tomorrow he would be coming. So day after tomorrow, if your lordship permits.
This is 783. What's the matter about Mr. Manthi?
The appellate order of the OA collector is under challenge. Your lordship annexed here.
No, this is not a Board of Revenue matter.
No, it is. Your lordship may kindly have a glance on order dated 22nd 11/2019.
Right.
The impugned order is annexure 19 at page 68. This honorable court has directed them to produce records or what has been raised in the writ petition. Those points were not raised before the revisional authority. There are private respondents also against whom the order is.
There's some interim order of status quo, right? Which is continuing for several years now. Yeah, status quo shall be maintained. This was in 2006.
Yes, ma'am.
Then there's a connected writ petition.
Yes, there is a connected writ petition that is also, I find.
7681.
1765 of 89. OJC 1765 of 89.
The record of OGC 1769 of 89. We summon for the next date. Oh, it's here. That order is here. 1 minute. Next 20. The encroachment appeal was asked to be heard on merits. So it's pursuant to that order that the encroachment appeal was heard and it's been decided against them. So it's a challenge to the order in the encroachment case asking them.
Thereafter, revision was preferred.
And revision also dismissed.
Dismissed. Appeal was heard pursuant to the direction of this honorable court.
Correct.
Then that order was challenged in revision, and in all the forums, the petitioner lost.
The DP Montil on counsel appeal to the petitioners is stated to be in some personal difficulty today. As a last opportunity in the interest of justice, list on 20th July 20.
Supplementary list item number 13.
13.
13, if I may please your lordship, my lord. My lord, the petitioner has challenged annexure 24. My lord, wherein
in this case, Mr. Das is appearing for one of the private project engineer. Let it be passed over. I am asking him to come.
All right, pass.
For Suarez board, opposite part number 2, Mr. Das.
All right.
Supplementary list item number 14.
And item 14, just now I received a regional copy. One time.
Copy may be served on me also.
Last time you had wanted to cite some judgments.
Plus, there is a constitution judgment of Honorable Apex Court in the case of the Indore Municipal Corporation case. Plus, here, the whole claim mirrors flows from the 1894 Act mirrors. Plus, land was acquired by the state government for the purpose of construction of asphalt of NALCO mirrors. NALCO claims to have their own policy for rehabilitation and resettlement. State government has also their own resettlement rehabilitation policy. The one I have annexed to writ petition is the state's rehabilitation policy. Now in the counter affidavit, NALCO says that we have our own, but that resettlement policy is approved by the board in consultation with the officers of the state government. So that is how you will be governed by that. But basically the point which is involved for lordship's consideration is whether I will be falling under LAP or SAP. There's a less affected person or substantially affected person. So far as that issue is concerned, I found that both the conditions of the policy, so-called policy NALCO, because NALCO appears to be a scheme, not a policy, but apparently both the conditions are differently worded with same objective. State government says the land loser, if he loses land up to the extent of 1/3, then he will be an affected person. But on the other hand, NALCO policy says that if the land left after losing for the acquisition is 2/3, then you are also affected person, substantial affected person. So leaving 2/3 and losing 1/3, impact is same.
Right.
And the difference is that under the NALCO policy, if the losing land is more than 1/3, I will regard as SAP, substantially affected person. But the only one point I find what has happened, they merely calculate total holding is 5 point some acres and land lost by you is 1.65. It calculates to 30.1. My case is that there is a land under Khata 148 in the name of Lavanya, in which the father of the petitioner is a inheritor. And if that will be added, and in respect of that land is acquired by, there is no controversy because the counter I have checked up, in the rejoinder I have clarified that if I have filed that. They don't, in their reply, they are silent. Because that 30 acres of land in which I have the share of 0.310 decimal millers, if that will be added, that will be more than 1/3. My lords may kindly see my rejoinder. And till today, no compensation, no award, nothing is passed in respect of that land, even if that is acquired for asphalt millers. And Honorable Apex Court, referring to section 24 millers of the 2013 Act says, if any claim is left without any award or no compensation granted, that can be dealt with under 2013 Act. That is precisely my case.
No, but if no award, para 10, just come to para 10 of your rejoinder.
Para 10 of the rejoinder, my lords. My lords. That Bagayat Kisam land of Khata number 148 of Kansar Gadi recorded in the name of Lavanya Pradhan and others, in which Kathi Pradhan the father of the petitioner, has shared to the extent of 0.31 and in respect of the said land under Khata 148, no award is passed nor any compensation paid till date, even though the same is acquired by NALCO for construction of ash pond.
See, this is the whole point. If it is not acquired, no award has been passed, then how can we treat this as something that is acquired?
Because then, Section 24 of 2013 Act says, the remedy doesn't stand extinct. It still stands. Because 2013 Act says that Indore Constitution Bench judgment, because if something is pending, not considered, no award, then that can be dealt under 2013 Act.
No, I don't understand. What is that, sir? If it is not acquired, how can you treat it as part of?
Not acquired. Acquired, no compensation paid, no award passed. It is asphalt has already been constructed over that land. That Khata number 148. That is the case, Milords. It is not that this is not acquired. This is acquired, and Milords, construction of asphalt is already built over this land, but still, Milords, no award, no compensation.
Who's going to verify all this?
My lords.
Who's going to verify whether this 0.31 has now been? First of all, that it belongs to you. How do we know that?
Yes, now there is your lordship have appointed 3 district judges. There are now 3 rehabilitation authorities appointed in our state, Milords. Almost in 30 districts, one authority having 10 districts under, and I fall under Milords this rehabilitation settlement authority of Anugul, Milords.
So if you want to go there, you can go before that.
Sambalpur. Yes. If your lordship can relegate to all consider all my lords.
All right.
The acquisition, land acquisition in 1982, they have preferred a repetition in 2012, my lord. After so many years, cannot be maintained. Land acquisition act acquired in 82. Policy comes in 94. Now in 2012, they have filed a preferred repetition, which is not maintainable.
So this petition has been pending here for 10 years now.
That now
and status quo was passed in 2006. Is it? When was that status quo passed? No. But notice was issued, sir, way back in 2012 itself. So the petition was entertained.
Well, I have filed my counter, say, disclosing the state government policy is not applicable to us. Where NALCO policy is 84, and in 84 policy it is mentioned. It is within 1 year it will be closed, my lord. Policy in 3.2, my lord, may be seen. Now in 2012, they have come to this honorable court. My lord, in
Section
my counter, my counter policy has in annex, my lord.
24.1 will not apply here, sir.
24.1 read with 24.2, my lords, may kindly see. I don't have book, my lord, sorry.
NALCO counter, my lord, page 11. Internal page 11.
No. First of all, we don't know if this is part of the notification acquisition notification at all. We don't know that.
Plus, your lordship may kindly see the pleadings, my lords. I take your lordship's attention to paragraph 6, my lords. Para 5 at page 6, my lords, may kindly see. Para 6 and 7 at page 5. So, sir. Page 5. Para 6 years. It is humbly submitted. NALCO opposite party number 4 has acquired 1.65 decimals of irrigated land and Acre-soon 317 decimals of Bagayat land belonging to petitioners. This acre 317, which I pointed out, that land. As per the National RR policy 2006 and 7, 1.65 irrigated land is equivalent to 3.30 decimal non-irrigated land. That is also flows from the definition of a small farmer, marginal farmer. Similarly, as per letter number so and so, Secretary to Government in Revenue Department, Acre-soon 165.
Let's see what the reply to para 6 is.
Para 6 bills, they have no reply. And I have said it is pending. My lords will find.
No, let's see what they reply to para 6 is.
In the counter, you will kindly see. Counter reply is at para 9. Paragraph
9, yeah.
Paragraph 9. Paragraph 9. That as regards to averment made in 6 and 7, it is submitted that submission made therein in para is not correct because Out of total 5.45, only 1.65 is acquired for construction of land. About 317, it is silent. They have not replied anything, Milos. There is no
If
reply.
it's not acquired, then we can't presume it has been acquired. The
My
specific government is it's not been acquired.
Specific government, my government is that it is acquired. And over
No,
that,
so who's going to resolve this? This is the whole point. Who's going to resolve this?
I think now the authority is constituted under the Act, Milos, they will.
No. At which stage is also the question? Because they say NALCO's rehabilitation policy is open for 1 year. Whereas you've come in respect of an acquisition. When was this acquisition?
Acquisition was in 1982.
1982.
And you filed this 30 years later, sir.
82.
The petitions filed in 2012.
Then your lordship considered because my series of representations are pending. And not only that, your lordship knows that only cultivable land for a farmer is so precious, Milos. Once he loses, I don't have any other income to survive. And Milos, that land, Milos, 30 acres, Milos, in the name of Lavanya Pradhan, it still remains with that unresolved, Milos. No compensation, no award. No compensation, no award.
No. They say it is not even acquired, sir. 1.65 has been acquired.
Let them give a specific reply on that. They have
they have. Para 9 of their reply, they have replied.
They only,
your para 6.
They only tell about 5.45, in which 1/3.
They're very clear, sir. If your government in para 6 has acquired 1.65 decimal of irrigated land and 0.37 of Bagayat land, they're not admitting this. They're not admitting to acquiring 0.31 Bagayat land.
Milos, para 6. Your lordship, kindly read the last sentence. In addition to this, my lordship, kindly see. In addition to this, the opposite party company has also acquired an area of 0.03.
This they have not admitted, sir. Now come to the reply para 9. Para 9 of the reply.
My lords.
They only admit 1.65.
And on this, they could have said no.
That is also the argument of the government counter. The government has also filed a counter. That also is.
No, I don't have any counter of government. I'm sorry to say. I have only counter given by
filed a counter.
NALCO.
That is also 30.2.
Para 5 Milos of my
This counter is by 3 and 4. NALCO.
No, para 5. You can read that.
Please. That in reply to the governments made in paragraph 1 of the writ application.
Counter dated 8/9/17.
Yeah.
It is submitted that in 4/1 notification so and so dated 15th of July 82 was issued by government of Orissa. So and so shows that khata number 11 measuring area of 1.65 acre of village so and khata number etiki stand recorded in the names of Nabin Chandra Pradhan. So there, with regard to their ownership, Millards 5.45 is there. Then Millards, if Millards comes to about 5 lines below, total land held by the family was 5.45 acres, out of which an area measuring acre 1.65 was acquired, which is about 30% of the total land.
There is no dispute over that.
Therefore, Millards, that is why Millards, it is since it is not 33%,
right?
So they are left with more than 2/3.
Right. That is more than 33%.
So that is the issue, Millards. And therefore, Millards, if they come under the 1989 policy,
so they are not substantially affected.
Yes, Millards. So because in the 1989 policy, there is an equivalence given to the non-irrigated lands and the irrigated lands, which Millards they won't get under the 1984 policy. And since NALCO has to give the employment, so NALCO's submission is that our policy is the one that rules the field. So that is Millards, in fact, the issue. Because is acquired and that is undisputed.
So what he's trying to say in the rejoinder is that 0.31 is also acquired.
Yes.
Which is not agreed to either by the state or NALCO.
Page 34. My lordship, kindly.
Yes.
Page 34.
Yes.
Because all descriptions are given, if your lordship permit me.
Yes.
Para small d. Moreover, in addition to that, what my land friend is submitting, that 5 point. I have lost some extent of land of Bagayat ki, some khata number 148 of village Karnasgadi and recorded name of Lavanya Pradhan others. In ROR 197 of khata 140, that is entry like Bauri Pradhan, son of Swanso. Several times I have pointed out before special LAO, NALCO and DM Anugul specifying that there is no such person name of Bauri Pradhan, son of Sahib Pradhan, but there exists person like Kati Pradhan, son of Sahib Pradhan, and Bauri Pradhan, son of Hati Pradhan. Arovar so and so 145 speaks about presence of 9 mango trees, so and so palm tree in the name of Milu Pradhan, Reka Pradhan, so and so Kati
Sir,
Pradhan.
there's no date on this. Anyway, sir, the point is, what is the date in Oriya it's written?
But just one line. I mean, I'm so sorry. Just one line below. For the above land, no award has been passed, nor any compensation has been paid till date. Though 29 years has already been passed since
That's the
acquisition
point.
of land has been.
That's the point, sir. You have come actually after 29 years.
But your lordship,
Just before filing the petition, you've made this representation. And then there's a disputed question, sir. Both state and NALCO say they've not acquired 0.31.
Therefore, Honorable Apex Court said that in case of acquisition of land, if no award is granted,
No. If it is acquired, like you say, then it's fine. They say they have not acquired.
Acquisition is disputed.
Now your lordship now have the crux. But who can say? If I say, and it's a matter of
fact. There's a limitation to writ jurisdiction, that's for, sir. And also time. When you come after 32 years, 34 years.
Taking the limitation.
Man is struggling with decades.
Also passed the order earlier that making representation after 30 years.
The same Lavanya Bera. No, this is somebody else.
Somebody else, but the principal, my lord, has shut out.
And they
principal,
say,
my lord, has said that such a delay of 32 years cannot be considered in the court. Representation is filed after 32 years.
They say that no benefit of employment can be granted to LAP, less affected. But I have annexed RTI information along with the rejoinder, where 512 persons are given employment.
Yes.
Those who are covered under LAP category.
Correct.
But, so the counter doesn't tell the truth. It is not what has happened. But if at all in their own voice, if I come under LAP, if 512, why not me?
But again, at what stage you come and ask for this is also important, sir.
And substance.
Not after 32 years.
Millers, I have annexed also one ROR. My lords will find rent receipt and ROR. I have paid rent on that. That Bhagavat land millers. If that will be added, the percentage will be more than 1/3.
If they have acquired, it should be added. So if
exactly,
not,
millers.
Yes.
That is the point. Millers, supposing if your lordship find that in fact it is acquired, they are not admitting. And asphalt has been millers constructed over my land, millers.
How do you find out all this, sir? We are not here. We are not Amins. We are not going to go there and survey the land. We are going to go by the affidavits of the authorities. How can we?
So therefore, millers, that because there is conflict, millers, these have to resolve, millers. I understand your lordship here cannot, millers. Let you relegate it to the authority, millers.
No. That's not. It's 32 years, sir. Now it's all right. All right. We'll pass the detailed orders. The writ petition is dismissed. All right.
Supplemental list item number 15.
May I please, your lordship?
Yes.
Item 15, your lordship, kindly see the last order dated 10/5/2022, your lordship.
Yes.
Your lordship directed to the London State Council to file the counter reply. They have not filed till that.
What's the matter about, sir?
Your lordship, the matter is pending before this is the petition challenging the settlement of the land.
Okay.
Some land has been settled in favor of someone that has been confirmed by the appellate sub-collector. He is challenging that.
No, this is an order in an encroachment case.
In encroachment case, there is a provision under section 7A of the OPLD Act. The land can be settled, and that provision was invoked by the authority, and it was settled. And the person in whose favor the land was settled, he is perhaps he is the opposite party.
Opposite party number, your lordship.
Hi. Ramkumar Mahanti. And all these petitioners are purportedly the villagers of that area. They challenge this settlement. On
that issue, your lordship, last occasion directed to take the reply, file your lordship within a period of 2 weeks. Your lordship, kindly see the last order 10/5/2022, your lordship. Thereafter, the directed to regender to be filed.
So when was this impugned order passed?
Impugned order, your lordship.
Oh, we have filed a counter affidavit, my lord.
So
There is a
copy not be solved.
No, 28 June 2001.
Yes.
My lord, the private opposite party has filed a detailed counter affidavit on 15th March 2022. Mr. SP Misra, senior advocate, is appeared. 22nd March.
So 2001 order you're challenging in 2016, sir.
Yes.
What's the explanation for the delay? Counter affidavit. Where is this counter affidavit you say of opposite party number 5?
That is there. We have been served with a copy that is dated 20.
Mr. Mishra, you're appearing? Mr. SP Mishra?
Mr. SP Misra. 22nd March 2022.
You're appearing for opposite party number 5, sir. So you're not audible.
No, sorry.
For OP number 8500. Here, if your lordship kindly see my application for intervention, paragraph 10, 11, and 12. Paragraph 10, 11, and 12.
No, we don't have your application for intervention, sir.
Yes, but that is IA 17108 of 2021.
No. Sir, you are talking of item 21.
Item 15.
Item 15 it is.
So 15, item 15. We are in item 15, sir.
No, 15, sir, I am not there.
No. In item 15, he is not there. I'm sorry. In item 21.
Item 18 and 21.
No, no counter has been filed here.
Item
15. You'll have to file a reply, sir, then. Mr. Bonti, you'll have to file a reply.
Yes. Last opportunity to the opposite parties.
See, main contention is in para. They're saying it's a public road.
The lordship may kindly verify whether the notice against OP number 5 is served or not, because he is the beneficiary of the impugned order.
Correct.
Notice has to be served.
Already solved, your lordship. Already solved.
He has been set expiry.
No, he has not appeared.
Has he been served? Jesse?
For a moment, your lordship kindly, your lordship verify the order dated 10/5/2022, your lordship.
No. Whether the notice is served on, yes, that is to be, because he is the beneficiary of the,
that
so
is
necessarily
that
he is to defend his.
Opposite party notice has been already solved. OP number 5 has not appeared, I think, your lordship.
What's the explanation of the delay, sir? 15 years delay in filing the petition?
That part, your lordship, have not prepared.
Nothing's there, sir. Para 15 come to that.
And the land is already settled for last 2 decades. And that is confirmed by the sub-collector. Some of I apprehend there must be some rivalry between 2 groups of the, but everything was carried out in accordance with the rules. But now they are claiming that this order should be set aside after more than a decade.
Let them file the reply.
When was notice issued, sir?
That notice has to be served because he is the beneficiary.
Counsel the petitioner, when was notice issued?
Not safe.
Lordship, I will verify, Your Lordship.
No, no. we
Because
have it.
last two orders, Your Lordship, before that order 15/3/2022, Your Lordship.
No, but no notice has been
All
issued,
these
sir.
orders
We are
directly
presuming notice issued. No notice has been issued.
Your Lordship, for a moment, Your Lordship, kindly the.
You went on saying notice has been issued, served, everything you have said.
Your Lordship.
No notice has been issued.
Lordship, for a moment, Your Lordship, kindly see the order dated 15/3/2022, Your Lordship. Mr. Essendas, London Addition Standing Council for the state states that he will assert in the present status of the land
That is
in
there.
question
That is
and
there.
revert on the next.
What is that to do with this court issuing notice to opposite party number 5? Opposite party number 5 being served? Where is all that? There is no notice issued in this. Just show him there's no order issuing notice, sir.
So last occasion, Your Lordship's directed Your Lordship
So
to
presumed.
take the reply.
You are the counsel for the petitioner. You are not able to say if notice has been issued. And you are also saying they've been served. You're repeatedly saying notice is issued and notice is also served.
And that apart, I think there is a revisional court to sit to decide the legality of the sub-collector's order on the appellate jury. That I am verifying. They can file revision before.
No, but that also will be very late, sir. This is
It is also late. After 20 years, such a liberty is also uncalled for.
Lordship, all right, Your Lordship, kindly taken tomorrow, Your Lordship.
No. How between today and tomorrow, what will happen? Notice will go.
No, Your Lordship, what?
Notice has not gone. So we may have said opposite party should file reply.
Yes.
But if no notice has gone to opposite parties, how will they file reply?
Your Lordship, on last occasion, Mr. Mishra is, Your Lordship had this matter before Your Lordship. So on that date, Your Lordship directed to take the instruction and file if any reply to the.
No, we only ask him to not file a reply. We only ask him to find the current status.
Yes. So I pray Your Lordship kindly taken tomorrow, Your Lordship. Mr. Mishra will argue this.
No.
Your Lordship kindly consider.
Sorry. Not after spending so much time.
Your Lordship, Mr. Mishra is suffering a throat infection.
Sir, all that you're now saying after 15 minutes. Because you want now somehow to get an adjournment.
Because of
in the last 10 minutes, you did not utter a word about anyone else appearing, anyone else having sore throat, nothing.
Yeah, because
when you know that you have difficult questions to answer, all this is coming up.
No, I'm a pardon, Your Lordship.
Yes.
Your Lordship,
sorry.
Last occasion, Your Lordship directed to last.
Sir, we didn't notice.
Last opportunity.
You did not bring to our notice that no notice has gone to any of the respondents. Notice has not been issued in this petition even once. And there's no explanation for the delay. Yeah.
There is no state. The record must have been corrected in favor of the.
You say the challenge in the present petition, which is filed on 19th August 2016, is to an order dated 28 June 2001, passed by the sub-collector Bhadrak in encroachment case number 171 of 2000. Full stop. Although the petition has been filed more than 6 years ago, there is no order yet in this petition issuing notice to any of the respondents. Full stop. As a result, the opposite party number 5, in whose favor the order was passed by the sub-collector on 28 June 2001, settling the land in question in his favor under section 7(1). No, under section 8(a) of the OPLE Act, has not been served any notice till date. Paragraph. Consequently, there is no occasion for the opposite parties to file any reply affidavit, although this was directed on the previous date by this court. Stop. It was not brought to the attention of the court on that date, that is 10/5/2022, that till date no notice had been issued to any of the opposite parties. Paragraph. Just see this amendment application. I don't know if you have a copy.
Amendment. Yes. 9/11/2000.
Amendment also. There is no copy in my file.
And it's been allowed. Just look at the amendment applications.
He substituted the prayer. Number one. Yes.
I don't understand. How can the sub-collector cancel his own order? Settlement be made by lower court. Cancellation settlement be made by lower court, Tahsildar Basudevpur.
Yes. He's saying that it is already again recalled by the same authority. So it can be.
No.
Is that possible?
No, 11/17 No, that's the
I think you'll have to examine this and tell us what the position is.
My lord, right now I got
This
a
last
letter
time-
from the Tahsildar.
This is only a typed copy, so we're not clear what this is. The
Yes.
7/7/2006. Paragraph. It appears that by a order dated 7/7/2006, passed by the sub-collector Badrak, the settlement of the case land in lease case number 171 of 2000 was cancelled. Full stop. As a result, miss case number 13059 of 2017 was filed by the petitioners in this court, seeking to limit the prayer in the petition only to enforcement of the above order, cancelling the lease in favor of opposite party number 5. Paragraph. In the above circumstances, the court would like the opposite party state to inform it in the first instance what the position in
My
regard
lord,
to
I may be permitted. just now I have received a letter from the Tahsildar showing the status of the land. That is, there he has mentioned the status, field position, ROR position. So everything is there. Shall I file it along with an affidavit or?
No, what it is, you can tell us.
Yes. The ROR position is, as per major settlement, this particular land is unauthorized possession by Surendra Mahanti, son of Chintamani Mahanti. Subsequent ROR position, this is the name of the recorded tenant, Ramkumar Mahanti. That means by virtue of the sub-collector's order, the ROR has been changed in favor of opposite partner 5. Present ROR position, Mauja Bastampur, so Ramkumar Mahanti, still he is in the recorded tenant. And other one is Jatindra Mahanti, son of Jagabandhu Mahanti. Field position. This plot situates just adjacent to the east of the Basdevpur Baleswar Salt Road. The 4 numbers of shop houses are over the plot. The total length of the houses are 70 feet in north-south direction and 20 feet in breadth with east-west direction. The walls of the shops are made in bricks and the roofs of the houses are covered by asbestos. Out of the 4 numbers of shops, one is variety shop, one is jewelry shop, one is one so. Different persons from different places are carrying their business on rental basis. The record position is that it is in the name of opposite part number 5. And there are several tenants occupying the shop rooms, which is located over the suit land.
No, then what happens if this lease has been settlement has been cancelled?
This fact which they brought by way of amendment, that it is this amendment petition maybe that is already allowed amendment that I find.
Yeah.
Let me take instruction on the because if the sub-collector has recalled his own order, then everything, the petitioner's redress, the grievance has been redressed.
Correct. No, but it has to be implemented. He says the ROR has to be implemented.
Yes, it has to be. And as the current status seems that it has not been implemented. This is what the Tahsildars. Let me take instruction on this issue.
You see, the amendment application was allowed with the scope on 9th November 2017, paragraph. From the instructions made available to Mr. Mahanti, it appears that the ROR still stands in the name of opposite party number 5. In the circumstances, it is not clear if the order dated 7/7/2006 of the sub-collector cancelling the lease, cancelling the settlement in lease case number 170 of 2010, of 2001 has been implemented. Mr. Mahanti states that he will seek instructions on the specific aspect. List on 28th September.
Supplementary list item number 16.
May it please your lordship.
Yes.
My lord, on the last date, your lordship had directed the state to open instruction as to the state installation.
Filed the affidavit of the Fisheries Department on
transponders and filling of vacancies.
I have filed the affidavit.
With respect to transponders, they said they have invited a tender, but no one has participated. It got cancelled. Again, they have invited. I think there is some loophole because in Chennai, about 5,000 transponders have been installed. So they should sort it out at earliest as possible. That is the major issue here. The tracking of trawlers, and as your lordship has seen, time and again they infringe into the prohibited area. And then there is a
hard tender. We have relaxed certain conditions for wider participation.
Correct.
That we have stated in paragraph 5 of the affidavit.
No, there's nothing stated.
No, today I'm filing the hard copies. Well, you'll also first see the affidavit dated 7/7/2022. That is by the Fishery Department. Paragraph 5, you'll also mention that as no bids are received pursuant.
Correct. You say on the issue of transponders, an affidavit has been filed on 7/7/2022, stating that the earlier tender floated on 18/4/2022 did not receive any bids. No, the earlier tender floated
10/12/2021. That was
on
first.
10/12/2021 did not receive any bids. And now the tender conditions have been floated.
No, thereafter another tender was issued on 18/4. Second.
That's
tender.
right. And the fresh tender has been floated on 18/4/2022. The last date of submission of the bids being 12/7/2022.
No, that is 7/6. That is 7/6. From 8 pursuant to 18/4, no bids also received.
All right, I think you just take this again. An affidavit has been filed on 7/7/2022 stating that no bids were received pursuant to two tenders already floated, that is 10/12/2021 and 18/4/2022. Full stop. It is stated that a fresh tender has been floated on 7 June 2022, with the last date for submission of the bid as 12/7/2022. It is expected that after the bids are received for this tender, the transponder orders will be placed for purchase of transponders as already directed. Paragraph. Another affidavit has been filed on 11th July 2022 stating that
Paragraph 3.
an advertisement, the process of recruitment for 143 posts of sub-inspectors of police has started from 2nd July 2022. An approval has been sought for conducting the recruitment of civil constables in 2022. Paragraph. A further updated status report by way of an affidavit be filed before the next date. Anything else we need to do, Mr. Agarwal?
No, Your Lordship, this much only. As per Your Lordship's endeavor due to record nesting of olive ridleys took place this year.
Correct. That's
So,
what.
2 lakhs in Shikulia and 5.2 lakhs in Gairmag.
Correct.
So,
All right.
because of Your Lordship's endeavor.
All right. So we list it on 17th October.
Yes, Your Lordship.
All right.
Supplementary list item number 17.
Your Lordship, item number 17 may kindly be permitted to be withdrawn.
Or counsel the petitioner seeks leave to withdraw this petition. Dismissal. The memo is taken on record. All right.
Supplementary list item number 18.
This
case, we have filed the intervention application, but in fact, if Your Lordship looks at paragraph 10, 11, and 12 of my application for intervention, I have indicated that the proposal for shifting has already taken place, and it has been taken place to Jageshwarpada, where the government has also given the justification site. Jageshwarpada consists of 6 acres and 50 decimals of government land of MSME department. And so the previous place is concerned, that was actually filled with forest lands. But the writ petition, previously another writ application was filed. The present writ petitioners knew about it, they didn't disclose about it.
Okay.
Same set of annexures were filed.
Yes.
But now the construction has already taken place. Your Lordship looks at paragraph 11, I have highlighted that. And also the work has been executed to some large extent. The public and children.
But this case, Lord, Lordship had this matter after the hearing, Lordship issued notice, and also directed State Council to file counsel. That's the counter, Lord. Still, till now, they have not filed counter, Lord. But here the case is like this, Lord. This matter has been this is relating to construction of
school.
Orissa Adarsh Vidyalaya, Lord. This case, after considering all the entire fact that the school, that this construction is going to be constructed in proper place, the committee has approved that, Lord. Lordship can see that the government has to file counter, that particular on that issue, when everything has been complied with. After immediately, at a short time, the collector has changed the view and directed that to be shifted to the other place, which is completely not fit for this construction, Lord. As per the guidelines, this school should be constructed at the proper place, which has been committee has been approved. Committee has been approved, particularly on that issue. Also directed State Council file counter. Why the view has been changed, Lord. And we have already that is the auction, that is the work order has been issued. And lots of the page 24 and it's 6. And it's 6. The selection committee has already approved. And that has at the verge of construction, blood had started. The immediately collector changed the view on being persuaded on political persons. And that too, this is the where now they are going to be constructed another place that is not fit for this construction as per their guidelines. What is the reason? But what is the reason for changing the particular that construction to other place? That was the issue. Option directed State Council to file counter particular issue. Why you have changed that? Because of some persons told that that will be done there, they will change the issue that is the plan. Collector immediately directed, and the committee has already approved. And all documents we have filed, Forest Department has already approved. Already give you.
You have this IA with you, 17108. It's an intervention application.
The number is not revealed.
You have a copy of the IA, sir?
It's not with me, Lord.
Mr. Mishra, I think you'll have to serve it on the counsel for the petitioner.
But the government has not filed counter, nothing issued. So I'll also reply that.
My response is that I am told it has been solved, but still then I'll solve again.
You do not have a copy of 17108?
No, I have not the copy.
No, notice is gone.
But the government has to file, it is the duty of the government to file counter to give the reply, particularly that why you have changed the voice. When the cost of lakhs of money has been spent there.
Why did you answer, sir? You have this IA or not?
No, that IA is not with me.
Your notice was issued on 5th January, sir.
Yes, Lord.
2022.
Since long notice has been issued, but they are not.
5th January notice was issued.
Yes.
And it's been said in para 2 of that order, copy of the application be served on counsel to the petitioner. Again, last opportunity is given
My
to the
lord,
state.
we file our counter affidavit, my lord, but I have a written instruction that as per that Adarsha Vidyalaya guidelines, minimum 5 acres land is required for construction.
Sir, you have to file an affidavit. What?
I will file. I will file.
You are given a last opportunity, sir. The matter has been going on since long.
My lord, I am so sorry, my lord. As last chance, the time small.
That last chance was given last time.
In the new place, the construction started way back in August 2021, 18/8/21.
Forcibly have started that. That doesn't mean that will be.
No, government decision.
That is the decision of the collector, my lord. Pursuant to that, it has been executed.
So overriding their own decision without any.
And the reason behind that minimum 5 acres is required as per the guidelines.
That I will satisfy. I'll satisfy. You give the reply first.
I will file.
Yes, I will give the reply.
The affidavit.
What you are going to construct whether that criteria is.
1 minute. IA 17108 of 2021. Although notice was issued way back on 5th January 2022 in the present application, no reply has been filed by any of the parties. Mr. Mishra and senior counsel appearing for the intervener states that another copy of the application will be served on counsel of the petitioner within 2 weeks. Next, replies to this application be filed both by the state and the petitioner within 4 weeks. Rejoinder if any before the state. In writ petition 32484 of 2021, counsel for the state assures the court that the affidavit will be filed. Reply will be filed on or before 22nd August 2022. Rejoinder if any be filed for the next date. This on 14th September.
Supplementary list item number 19.
May I please? This matter relates to include the present petitions in the GPF rules and OCS rules, my lord. A similar batch of cases, your lordships has disposed of on 19/4/2022, my lord. Batch of cases.
Do a paragraph 2 of that order
both these writ petitions can be disposed of because there is in these two writ petitions there is no rejection order.
All right. Just say, in view of the order passed by this court on 19th April 2022, in writ petition 7 30957 of 2021, bracket Rupesh Kumar Biswal, State of Orissa, it is clarified that the judicial order earlier passed by this court in WP Civil 15433 of 2012, bracket Anand Dash, State of Orissa, will be applicable to all the present petitioners as well. Same directions are issued in these petitions.
Both. Supplementary item 20.
My lords, on behalf of Mr. Chimenka, my lords, I seek one passover, my lords. My lords, he is on his legs before the Honorable Court, court number 3, my lords.
All right.
Item 21.
Here in this case, during the pendency of the writ petition, the J form or encroachment order converted and lease has been granted in favor of OP number 5. I want to withdraw the writ petition to pursue the remedies available under the statute.
Counsel, the petitioner seeks leave to withdraw this petition with liberty to pursue remedies under the statute. Disposed of is withdrawn with liberty to wait for.
Item number 22.
22, Lord, this is covered by your lordships. Your lordships have issued notice.
22 and 23, there are two matters filed by Bhushan. In the second matter, item 23, we have filed the counter. And in item 22, we have not filed, we will file the counter. Your lordship may grant some more time.
And 23 also, your lordship may give me a short date to give a response. It is almost covered by your lordship. That is charging royalty and water cess.
Right.
Before the insolvency proceeding, my lord, where the plan has been already approved and the appellate authority has also approved it.
All right. You say 7710, Mr. Mudali prays and is granted 4 weeks time to file a reply. Rejoinder for the next date, interim order to continue. In 7783 of 2022, Mr. Ashraf Mohanty and senior counsel states that rejoinder will be filed before the next date. Both these matters you see list on 27th September.
Interim order may be continued.
Yes, continued.
Supplementary list item number 24.
Item number 24 minutes, your lordship directly filed counter, no counter is filed.
Okay. Last opportunity to file reply. Who's filing? Who's for the opposite side?
I think Mr. Chimenka must probably
to file replies within 8 weeks, rejoinder for the next date. List on 18th October, interim order to continue.
Supplementary list for hearing item 25.
Lord, may it please, your lordship.
Yes, please.
Lord, your lordship may take up the third writ petition, Lords. 7786 of 2005.
Yes.
Lord, let me tell you, lordship, what this case is all about.
Yes.
Lord, we had coal supply agreements.
Yes.
With the Mahanadi coal field.
Right.
And the price was fixed from time to time. I'll show the documents. Just give it to me. The government of India said, we will now conduct e-auction and that will be the price of coal. We come before your lordships. Your lordships say you continue paying. The amounts will be kept in an interest-bearing account. If you succeed ultimately, you will get back with interest. Now, in the meantime, my lords, Ashoka Smoke Mills comes into the Honorable Supreme Court. They quash the e-auction and they say make all the refunds. Our writ petitions are all pending here. Now, there are other writ petitions from different high courts which travel up to the Supreme Court. And there the Supreme Court says in all those judgments that you pay whatever you have collected. Broadly, that's our case. Would your lordship see minutes? Page 13, at page 15 is the agreement I have for coal supply agreement. I quickly take your lordship to those. It is page 13 minutes.
Who's appearing for Mahanadi Coalfields?
My lord friend.
One thing with my permission. Here, my lordship, there is Oscar smoke that covers one. It's that I don't dispute, my lordship. Initially, my lordship, the writ petition was filed in 2005. We have raised objection with regard to maternity on the ground that the petitioner being a company, it should have been represented through, as per the section 291 of the Companies Act. It must be authorized by the Board of Directors. In that case, the petitioner company was represented by a law officer. That objection was raised. The matter was heard on many occasions. In 2011, this court also directed the petitioner to produce the memorandum and articles of association. In the 2015, they have amended the petition, incorporating that the person authorized by the Board of Directors.
So that's over now.
Yeah, that's so. Achha. That they filed in 2015, my lordship.
That's all right, sir. That's over now. Now there's an authorized person representing them.
So for the as per the direction of this court, we have already that 1 crore 11 that is kept in separate. That is the.
No. Are you prepared to return the money? That's the only question here, sir.
Lord, he has filed an affidavit. If your lordship sees, Millers, flag C.
Yes.
Lord, I was claiming 1.64 crores.
Yes.
My learned friend has filed a reply at flag C.
Yes.
Where he says, my lords, it's 1. If your lordship kindly sees,
5.4.
He says it is 1.112449. That is page 3.
Correct. The detailed statement showing notified price.
Yes. I will take that, my lord. I will not dispute.
All right. So when will you pay it? That's the only question.
With interest, his lordships have said. With interest.
That is kept in separate. So far, the other route
petitions in para 7 of the counter affidavit filed by the Mahanadi Coalfields Limited (bracket MCL), it is stated as under reach notice the whole of para 7. Mr. Ashok Parijal and its senior counsel appearing for the petitioner states that the petitioner is agreeable to accepting the above amount towards together with the interest as already ordered by this court in its order dated
27 June 2005, 27/6/2005.
27 June 2005, in full and final settlement of its claims. Paragraph in that view of matter, a direction is issued to the MCL to pay the aforementioned admitted amount together with the interest. Is what rate? We have said no.
Your lordship said it will be kept in a separate interest-bearing account.
Interest-bearing, whatever.
Together with the interest that is accrued.
Your lordship.
Since the amount was was kept in an interest-bearing account as directed, to the petitioner within a period of 8 weeks from today.
4 weeks or 5 weeks.
All right. Within 4 weeks. Okay, within 4 weeks from today.
Lord, there is one more writ petition, 7529.
So this is 7786. This is disposed of.
Yes.
In that case, my objection is that all those cases, there is a linkage system. As per the agreement, you are supplied a particular quantity at a particular rate. In that other 2 cases, that are arising out of one case, that in that case, they have purchased coal beyond the agreed quantity. As per the agreement.
No, let me tell you. That is the third case. My learned friend is talking about the third case. That is 24, but 7529 is identical.
Yes.
7529 is identical.
Okay.
And 7529, if your lordship sees flag C, the agreed amount is, my lord, at page 2. Page 3, it is 1.55.
That's right. No, 116.
Yes, 116. Lordship is right.
Right. So in that 7529 of 2005, same para 7 of that writ petition, and then the same orders.
Same interim order.
Now third petition 2482. That's also disposed of.
That 7529. That is connected with 2482.
No.
One person is one.
No. Two same petitioner, one cement factory, one refractory factory.
2482, tell us now.
2482 that we have said that they were allotted a particular quantity and now they have purchased beyond that agreed quantity. As per the agreement, suppose they are agreed for MCL agreed to supply 1000 at particular rate. Now, as per they requested, they were supplied beyond 1000 tons, whatever it may be. That is beyond the contracted quantity, agreed price. That is what. We say that that is not covered under that 2007 Supreme Court judgment. That is what.
Yes, please.
My lords, the only difference this case with the other cases is that in the other two cases, the quantity was to be supplied pursuant to a linkage system under the contract. This is the quantity I have purchased because I need it for my refractory unit over and above that contracted quantity. Why I'm saying this is covered under the same Supreme Court decision? Because the e-auction system subsumed not only the linkage system, but also the open sales scheme from which I was otherwise entitled to purchase at a notified price. Now, all I'm seeking in this is the differential price between the notified price under which I would have purchased under the open sales scheme versus the e-auction price, my lords. My lord may see the Osaka smokeless judgment. I'll share the copy.
No, I think the point he's making is that you purchased more than the entitled quantity.
My lords, I was entitled to certain quantity under the linkage system, my lords, but I needed more for my refractory. How I used to make up the balance was to purchase under the open sales scheme as a general buyer trader at a notified price. In fact, one batch of writ petitioners before the Supreme Court in the Ashoka smoke list were traders who were purchasing from the open sales scheme, my lords. And they were also entitled to the refund of the differential amount. So I'm saying I'm anyway covered by that decision, my lords.
No, this is because you were compelled to go in for e-auction. You had to end up paying more, is it?
Yes, my lords. That's my case. Yes.
So again, promissory estoppel, and therefore you're entitled to.
My lords, they're a monopoly, my lords. The Supreme Court notes that I had no option but to purchase under the e-auction.
There are two affidavits filed by them, is it?
My lords, what happened was they had initially filed a counter affidavit. Then we amended the writ petition to bring on the authorized representative. So they filed a reply to.
I see.
May see para 42
of Ashoka smokeless.
Yes, ma'am. It's at page 64 of the compilation.
Right. Open sales scheme.
Yes, ma'am. And my lords can see thereafter para 72. Open sales schemes. I'll place para 42. On or about 3/11/1998, open sales schemes were introduced as a result whereof some amount of coal was to be supplied to the traders directly, wherewith the linkage system has nothing to do. It was clarified that OSS in no way affect dispatches to linked sponsored consumers. So this doesn't affect the linkage quantity which is supplied, but over and above, if I needed to purchase the quantity, I had to go under the open sales.
So what is their defense? I mean, what are they saying? Why are they not liable?
Then, my lords, they're saying because I bought under a open sales scheme, I come as a general buyer, a trader, and therefore I'm not entitled to challenge the e-auction process because somehow I am acceded to the e-auction price. My lords may see para 72 at page 6, internal page 71 of the companion.
Yes.
There are 4 categories of consumers who are aggrieved by the introduction of e-auction may see 1, 2, 3, and 4. The fourth category is the traders' minds. And the traders made their submissions at page para 81, which is at page 74. And my lords, all of the classes of petitioners got relief in the matter, and the entire e-auction scheme was set at naught by the Supreme Court, my lords. In fact, the Supreme Court in the second case, Eastern Coalfields versus Tetulia Coke, which starts at page 104 of the compilation. At para 10, notes there.
Sorry?
After the disposal of Ashoka Smokeless Coal India.
Where are you reading now?
Page 107, my lords, at para 10 of the judgment of Eastern Coalfields versus Tetulia Coke Plant.
Right. Yes. After disposal of Ashoka.
After the disposal of Ashoka Smokeless Coal India Private Limited, the writ petition filed by the respondent herein, just pending, was also considered, and the same was allowed following the decision of the court in Ashoka Smokeless. As by that decision, this court has declared the entire scheme to be invalid and ultra vires to the Constitution. Therefore, any action taken pursuant to the said scheme is also illegal and null and void. Following the ratio of the said decision, this court directed the coal companies to refund the price of the coal paid in excess of the notified price under the e-auction scheme. Certain guidelines were also laid down how such payments are to be made. This is the relevant part, madam. They have set aside the entire scheme.
My lordship, there is a language is beyond the notified price. What is the price? Notified means as agreed by the parties. That's what I want to say. That paragraph my friend was referring to. Beyond that, what is used beyond the notified price.
But the price, notified price, relates to the price which I would have otherwise purchased in the open sales scheme, not the e-auction.
E-auction price, correct.
In this case, there is an agreement.
Correct, but he was purchasing anyway beyond the agreement, sir.
My submission is that those extra quantities they have purchased.
Sorry?
That extra beyond the agreed quantity. That is the agreement. Under the agreement, MCL is between the MCL and the company. They agreed, there is agreement that will sell at a particular price.
We are not talking of that quantity, sir. Over and above that, it goes to the open sale system.
Yes, that is.
That's covered by this completely. All right. So what is the consequential order that has to be passed here?
My lords, they have to do the calculation now, and whatever they have collected in excess of the notified price, they will refund that time. We'll cooperate with them.
It will take some time only.
All right. You say present petition has been filed for a direction to the Mahanadi Coalfields Limited, bracket, MCL bracket, opposite party number 3, to refund to the petitioner number 1 company the sum of rupees 407,30509 together with interest, which according to the petition number 1 was collected from it by MCL towards sale of coal at prices determined by the process of single quotes e-auction. Paragraph. Petition number 1 carries on the business of manufacture of cement, refractory, and sponge iron Full stop. It is stated that the refractory division being in a non-core sector is entitled to purchase coal from MCL through its open sales scheme bracket OSS bracket at prices notified by it from time to time. Paragraph. On 15 June 2004, MCL notified a price list for different grades of non-coking coal with effect from 00 hours of 16/6/2004. Full stop. It is stated that till 2005, petition number 1 was purchasing non-coking coal at the prices notified until the introduction of an e-auction scheme. Full stop. On 9th May 2005, when petition number 1 sought to purchase 4,000 metric tons of 250 mm E-grade non-coking coal for its refractory division at the notified price, MCL charged it rupees 88,65,376 on account of introduction of e-auction scheme for determination of the sale price of non-coking coal. Full stop. Likewise, excess amounts had to be paid by the petitioner for the purchases made in the months of May, July, October for its refractory division. Full stop. Purchases were also made for its sponge iron division likewise. Full stop. The aggregate excess amount according to petition number 1, the aggregate excess amount paid to MCL for purchase of non-coking coal by the process of e-auction worked out to 407,30509. Paragraph.
Given a chart at page 28.
It's all right. This has been indicated in a tabular form at annexure 9. Full stop. Paragraph. On 1st December 2006, the Supreme Court invalidated the entire e-auction process by its judgment dated judgment in Ashoka Smokeless Coal India Private Limited versus Union of India 2007 2 SEC 640. So among the set of appellants before the Supreme Court were traders like the present petitioner who had to purchase coal under the OSS beyond the agreements with the respective coal manufacturing companies. This is plain from para 72 of the judgment of the Supreme Court, which sets out the 4 categories of consumers. And the 4th category are single quotes traders, unquote, which would include petition number 1 herein. Paragraph. Specific to the issue of the present petitioners, traders like the present petitioner number 1, the following submission was noted in para 81, take from A to A. Ultimately, accepting the plea of the petition appellants regarding the application of the principles of promissory estoppel and legitimate expectation, the Supreme Court invalidated the e-auction process.
Para 160 and 161 of the judgment.
Yeah.
Page 95 and 96 of that.
and held as under. B to B. Paragraph. The above by way of implementation of the above judgment, various petitions were filed in the high courts. By those compelled to purchase coal through the auction process for refund of the excess amount paid. One such case which landed up in the Supreme Court at the instance of Eastern Coalfields Limited was Eastern Coalfields Limited versus Tetulia Coke Plant Private Limited, 2011, 14 SEC 624. Arising from directions issued by the Calcutta High Court. The Supreme Court in that case observed as under C to C. Paragraph. In the present case, it is not in dispute that as a result of the invalidation of the e-auction process by the Supreme Court in Ashoka Smokeless Coal India Private Limited, Supra, the excess amount paid by petition number 1 would have to be refunded to it by MCL. However, counsel by the MCL states that the exercise of determining what is the exact amount payable to petition number 1 would require some time. Accordingly, a direction is issued to MCL to examine the details provided by the petitioner in Annexure 9 and after hearing the petitioner to pass appropriate orders within a period of 6 weeks from today.
My lords.
And to make the payments as determined within a further period of 4 weeks thereafter. Full stop. The petition is disposed of in the above terms.
All the three matters, my lord, I am appealing for the government of India.
All right, all right.
Supplementary list pastor matter item number 8. Item number 8.
None appears for the petitioner despite a possible dismissal or non-prosecution.
Supplementary item number 13.
For, if I may please your lordship, my lord. My lord, the petitioner challenges Annexure 24 by virtue of which the my lord, may I continue?
No, it's just because it's already under Passover, so it's already 4 o'clock. I'm just wondering. How long will this take?
Sorry, your lordship.
How long will this take?
My lord, 5 minutes. My submissions, 5 to 7 minutes.
All right.
5 to 10 minutes.
All right, all right. Carry on.
My lord, what is under challenge? I'll just explain in brief, my lord. My lord, I had entered into a contract by giving rates in the year 2004. My lord, there were various problems at the site because of which has been admitted by the opposite parties in the letters. I'll show it to your lordships. And the last letter being in the year 2009, April.
And in the month of, and your lordship, when they say me that you continue the work once again, they ask me for a very specific clause saying that I will not be provided price escalation clause, to which I reported that no, that is not the rate at which I can work in the year 2010. My rates were quoted way back in the year 2004, and forcing me and mandating me to work at those rates in 2010 cannot be done. And therefore, my lord, my contract has been terminated. And my lord, my security deposit, EMD and otherwise have everything been lapsed. I'll straight away take your lordship, my lord.
No, so what's your prayer here?
My lord, the amounts that have been forfeited, my security deposit and otherwise, my earnest money deposit and all of those things, my lord, that has to be returned, my lord. I am agreed by that part of the order, your lordship. That your lordship will find at page 24, annexure 24 at page 88. The whole security deposit, that is SD, deducted from from running account bills and EMD, IST of Messrs. BMC Builders Private Limited stands forfeited. My lord, I'm agreed by this part of the order. May I just take your lordships briefly, my lord, to their own admissions wherein they state as to the difficulties that have been faced by me because of latches on their part?
No, but all these are going to be disputed questions, right?
My lord, these are not disputed. My lord, it is their letters wherein they categorically admit that it is their faults. Your lordship may start with annexure 3 at page 29.
This would be some
Lord,
arbitration.
we have never accepted the grounds stated by the petitioner, my lord. Rather, in our series of documents we have annexed to our counter affidavit, it will go on to show that, my lord, repeatedly.
Usually these are matters for arbitration. There's no arbitration clause.
No arbitration clause, my lord.
My lord, I'm covered by a judgment of this honor. My lord, I'm covered by a judgment of this honorable court wherein similarly situated petitioners have been paid. My lord, the state authorities cannot take this plea, my lord, is what has been held.
If the facts are admitted, what you say is right. If
My lord, my lord, I'm showing their documents for your lordship's appreciation. I'll show their documents. My lord, before your lordship goes to the judgment, your lordship may just see their documents for a moment, my lord. My lord, may kindly have annexure 3 at page 29.
Annexure?
Annexure 3, page 29. My lord, I'll start from that.
This is going to take a long time, sir. This won't be over in 5 minutes, as they're saying.
Oh. My lord, whatever your lordship.
It will be highly disputed questions of fact.
Yes, my lord, let's have just one page for that, my lord, at page 57. My lord, admittedly, they state what happens, my lord. Page 57. My lord, this is a letter which starts at annexure 15, page 56. My lord, inspections done by them. My lord, the conclusions that they have arrived at on.
Normally, in an arbitration, the person who prepared this report will be examined as a witness.
My lord, this is their document.
On what basis he has said this?
My lord, this is their document, your lordship.
Correct. You would probably submit him as a witness to ask him to speak about this document.
My lord, the document.
We have short-circuited everything in red jurisdiction.
My lord,
what should be a civil suit for proof of documents, examining witnesses, examining experts?
Yes.
Everything is short-circuited. File a 226 for money. Basically, it's a money claim.
My lord, it is admitted that this person, their own official, the opposite parties.
According to you, say everything is admitted, everything should be allowed.
Lord, they're not disputing this document.
We'll hear him. Said you admit everything that he's saying.
No, Lord.
So that you start with that point. All right. If it was so simple, if he's admitted everything, then he wouldn't file a counter affidavit even.
That's right, your lordship. Your lordship may place this matter any other date. I'll convince your lordships on time, my lord.
List on 19th October.
My lord, the judgment will be taken on record, your lordship.
Nothing. You can always give us another copy next time.
My lord,
just give it back to him. It's better that way, sir.
Item number 20, sir.
This is a matter in which I am claiming that the revised returns filed pursuant to the commissioner's order granting me registration with retrospective effect for 3 years, 2003, 4, 4, 5, and 5, 6. Let the revised returns be taken on record and my case be examined on the basis of the revised returns. Whether I am entitled to 11 is for the officer to examine. This is all I am claiming. And it has taken a lot of time because of their inaction. I have been reminding them every now and then, every year, filing the details. And ultimately, when the order comes in my favor, the assessing officer simply says there is no provision in the act to give effect to a registration granted under section 12A. But that is not correct. Any registration which is granted to a charitable trust under 12A must result in the assessment, must be reflected in the assessment. I had filed revised returns. So the objection raised in the counter, there's only one objection raised in the counter, where they say there is a Supreme Court judgment which says if you want to raise a claim for deduction or exemption, you must do it only by means of a revised return. I have complied with that also. In July 2021, I have filed revised returns claiming exemption. Now they are saying there is no provision to give effect to this order. Well, all I am seeking is let the revised returns be taken on record. My claim be examined under section 11. I have got the registration. I applied in 28th March 2006. They granted me registration in 2017.
After 11 years.
After 11 years. Thereafter, I have been asking them to implement this. For that, they took 4 years. And in July 2021, I filed the revised returns. Because unless the registration is granted, I am not eligible to claim exemption under section 11. This is all the case. The Supreme Court in Dalmia, which I have cited, Dalmia Power, they have certain almost similar circumstances when the NCLT took time to pass a merger, approve the merger or amalgamation.
Right.
And the transferee company had to file revised returns claiming the brought forward losses from the transferor company. They said there is an impossibility here. We won't allow that impossibility to come in the way. And they said, file the revised returns, let it be taken on record, examine the claim. I am not asking for that I should be given the exemption straight away.
Right.
This is all the case. I have filed a list of dates. Lordship may kindly see the list of dates.
The last one.
20 up to 2002-3, I was not even required to obtain registration because my income was exempt as a major port under section 1020. But from 1/4/2003, that is assessment year 2003-4, section 1020 was amended to exclude major ports from the purview. So it became necessary for me to apply for registration under section 12A of the Income Tax Act on the ground that I am a charitable institution. But that I made on 28/3/2006. They said that there was a delay, long delay in application, in applying for registration. And then they rejected the application. I went to the Income Tax Appellate Tribunal. Income Tax Appellate Tribunal directed the commissioner to consider the delay for the assessment years 3, 4 to 5, 6. And for future years, he must grant registration. He implemented that. The second thing, that the future registration he granted immediately. But for the condemnation of the delay for the earlier years, he took a long time, very long time. And ultimately, the order was passed only on 23/3/2017, which is at page 3, item number 4.
Right.
On that date, he said that I am granting you registration for these 3 years also. So thereafter, the Lordships will see, I have made at least 6 requests, filing all the details, saying that an order has been passed by the commissioner, giving me registration. Please implement this order by examining my returns. They said, you must file revised returns. I filed the revised returns in July 2021. Now they say the revised returns cannot be given. The impugned order, Lordship will see the impugned order is at page
30.
30.
Yes.
Look, practically he has raised only 4 points. That is point number 4 to 6. 3 points, 4 to 6.
Yes.
I will read 4. Further, on the perusal of the ITR filed by you for the assessment years 3, 4, 4, 5, and 5, 6, it is seen that you had not claimed the benefit under
This is obvious because you had not got the registration then.
Yes, I could not have the original returns. I could not have.
Correct.
Further, your request to give effect to 12A registration for the period 1/4/2002 to
Again, the
31/3
limitation is they are doing because they held on to it till 2017.
17.
All right.
Also, in the case of Gedse India Limited, the Apex Court has held that it is necessary for an assessee to revise its return.
Now you filed a revised.
I filed it.
So you filed it in July, right?
In July 2020, 29th July 2021.
So this is after you filed the revised return.
Yes, this is
order has been
after I
passed.
filed the revised returns. Your Lordship will see the revised returns were filed on the page 30. What's that? 63, page 63.
All right.
Page 63. The letter is dated 29th July 2021.
So now there is no legal impediment from them considering your case.
Yes, this is all. Let them examine my claim. I mean, with reference to section
What do you
11.
say, sir?
I have just in my counter at page 3, I especially mentioned that without prejudice to the discussion made in the above, it is to be stated that section 1192B of the IT Act stipulates that an SEC can claim any addition, benefit, deduction, relief, exemption by making an application for condemnation delay before the competent authority, this Commissioner of Income Tax, if he is prevented by regional courts to make
all that is over, sir. This is what he's filed the writ petition for. So we won't allow you to raise the plea of delay, but you examine the revised return and pass an order.
Yes, ma'am.
All right. You say the Paradip Port Trust has filed this petition. Questioning an order dated 28th September 2021. Passed by the Joint Commissioner of Income Tax (OSD) Circle 1 Cuttack, rejecting the petitioner's request to give effect to the registration granted to it under Section 12AA of the Income Tax Act 1961 Act for the period 1st April 2002 to 31st March 2005. Paragraphs. The background facts are that the petitioner was constituted as a major trust under the Major Port Trust Act 1963 by a notification dated 27 September 1967 of the Ministry of Transport and Shipping, Transport Wing, Government of India. Stop. 1st November 1967 was the date of creation of the petitioner trust. Stop. On 28 March 2006, the petitioner had filed an application for grant of registration as charitable or religious trust or institution under Section 12 A (small a) of the Act, with retrospective effect from assessment year (AY) 2003-04 onwards. Full stop. This application was rejected by the Commissioner of Income Tax (CIT) by an order dated 29 September 2006. Full stop. The appeal filed against the said order by the petitioner was partly allowed by the Income Tax Appellate Tribunal (IT80) by its order dated 6th May 2008. Full stop. The CIT was directed to grant registration to the petitioner under Section 12 A with effect from 1st April 2005. That is from the first day of financial year (FY 2005-06) corresponding to AY 2006-07. Full stop. As far as the earlier period, that is AY 2003-04 to 2005-06, since the application for registration was held to have been filed belatedly, the IT80 restored the matter to the CIT for a fresh adjudication. Paragraph. The fresh order by the CIT on this part of the claim, that is for registration for the periods AY 2003-04 to 2005-06, was ultimately granted by the CIT only by an order dated 23rd March 2017. Stop. By this order, under section 12 double A bracket 1 bracket B bracket Roman small I, read with section 254 bracket 1 of the Act. The delay in the petitioner filing the application was condoned, and it was granted registration for AYS 2003-4 till 2005-6. Full stop. Paragraph. Thereafter, the petitioner filed at least 5 requests, written requests, to the CIT, requesting that assessments for the said years should be made after giving effect to the order dated 23rd March 2017 passed by the CIT. Full stop. On 24 June 2021, the CIT asked the petitioner to submit copies of its original income tax returns bracket ITRs and tax audit reports, and an original copy of the order dated 23rd March 2017, granting it registration under section 12AA of the Act. Paragraph. Thereafter, on 28 September 2021, the impugn order was passed by the CIT, where inter alia the request of the petitioner has been rejected on the following grounds. Which is that page?
30, page 30, annexure 1.
So in page 30, reproduce paras 2 to 6. Paragraph. This court has heard the submissions of Mr. Ishwar Leonard, Senior Counsel appearing for the petitioner, and Mr. Chimanka Leonard, Senior Standing Counsel for the department. As far as the aforementioned reasons given by the JCIT is concerned, it is seen that the ground that the petitioner had not claimed the benefit in its original returns is really without any basis, because at the time of filing the original returns, the petitioner had not been granted the registration for the AYs in question under section 12AA of the Act. Full stop. Therefore, it could not have made the request prior thereto. Full stop. This also answers the ground of limitation because, as was noted here and before, the CIT granted the registration under section 12AA for the AYs in question only on 23rd March 2017. And therefore, the petitioner could not be blamed for the delay in making the claim. Full stop. Thirdly, despite 5 written requests, 6, the petitioners, the opposite parties had not responded. Full stop. Paragraph. As regards the judgment of the Supreme Court in Getse India Limited versus CIT Supra, the requirement therein that a revised return should be filed has also been fulfilled by the petitioner. Admittedly, it has filed its revised returns on 29 July 2021. Paragraph. In Dalmia Power Limited versus ACIT 2020 420 ITR 339, the Supreme Court Which is the relevant paragraph here?
Not that, not that. There are 2-3 places where this paragraphs 9
Yeah,
where
Supreme
they
Court
say
took into an account
rules of procedure.
Yeah.
8 they state the dates. 9 they say rules of procedure cannot override the substance of the matter.
Right. Supreme Court permitted the assessee in that case. No, directed the department in that case to accept the revised returns filed by the appellants there for the assessment year 2016-17. Since the delay was on account of the schemes of arrangement and amalgamation being sanctioned by the NCLT, but not attributable to the assessee. Full stop. In the present case too, the court is of the view that the delay in the petitioner making a claim for giving effect to the registration under section 12 capital A, double A of the Act for the AYs in question cannot really be attributed to the petitioner in the facts and circumstances pointed here and before. It may be noted here that in the counter affidavit filed by the department, it has been stated in reply to paragraph 5 as under, take from page 66, open quotation, without prejudice to the discussion made above, up to which he has not done, unquote. The court does not consider it necessary at this stage, in the above background, for the petitioner to again make an application under section 119 bracket 2 bracket B of the Act for condoning delay for its revised returns to be considered and processed in accordance with law. The said delay should be taken to have been condoned in the facts and circumstances pointed out here and before. Paragraph. Accordingly, a direction is issued to the department, to the assessing officer, right?
To the DCAT. To his opposite party number 2.
Yeah.
Opposite party number 2, who's the assessing officer? The DCAT is the assessing officer. He has to be directed in terms of prayer B2.
Right. A direction is issued to the Deputy Commissioner of Income Tax, Circle 1, Cuttack, to process the revised returns of the petitioner for AYs 2003-4, 4-5 and 5-6, wherein the petitioner has asked for the registration under section 12AA granted to it by the CIT bracket E by the order dated 23/3/2017 to be given effect to. Full stop.
And also consider the claim of exemption under 11.
And to consider its claim for exemption thereunder. Full stop. The assessment order on the revised returns be passed by the opposite party number 2, that is the DCIT, after hearing the petitioner within a period of 3 months from today, and in any event not later than 10th October 2022.
Yes.
Full stop. The petition is disposed of in the above terms.
Grateful.
Right.
Great.